But maybe wanted to mention a restoration application, my lord. With
Notice, sir.
Yes, 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 with notice.
But upon notice, my lord, I am saying. Let it appear on Monday, my lord, because
You give the slip, it will appear. Date space, he will tell us to us, it will come in the list. Don't worry.
my lord, only because your lordship will recollect, my lord, on the last day. On the last week, I submitted to your lordship that I will be out of station for 2-3 days. That's why your lordship,
Tell us when you are coming back.
my lord, I will be coming on Friday.
Okay,
And
when
my lord,
would it
Friday,
be? Next Monday.
my lord, 15 is the last day for a stay of that order.
For?
For stay, that stay which has been granted by the learned trial judge, that is or expires on 15th. I mean, that's why I'm in trouble. Subject to your lordship, my lord, if it is taken up on to Monday, my lord.
ফাইলটা রিকুইজিশন করে
My lord, may I mention, my lord?
how many?
My lord, senior is waiting.
Yes,
May I seek my lord's kind indulgence to mention one matter? This matter was taken up by the Honorable Division Bench, said by your lordship, you are sitting with Justice Bitto. My lord, we took adjournment. But I am the respondent in the appeal. And my lord, the matter was your lordship's pleasure was that the matter should be posted after, my lord, 1 week after petition. Puja petition. But there is no judicial order, my lord.
no, is it you are mentioning upon notice?
Yes.
Give the slip.
Yeah, no, this-
একটু দেখে নিও
Lordship.
My lord, may I mention, my lord, one appeal lordship. This was, my lord, mentioning upon notice. Your lordship's, my lord, past and direction, my lord, for liberty to mention, and my lord, appointment of commissioner. This learned commissioner, my lord, his report is ready, my lord. He has communicated to us, my lord, and liberty to mention was given before you.
অরিজিনাল সাইট
No, lordship, appellate side, it was, my lord, specially assigned, my lord.
Lordship, may I have your lordship kind leave to file on application? Lordship, this matter is pertaining to the Jiaganj Nursing College matter. The matter was taken up before your lordship on 31st of October, wherein the university was directed.
we can't give it.
Lordship, mentioning
Your
upon
notice.
lordship, this
We
matter.
told your senior that give a notice and mention.
Lordship, we intimate everyone on the previous occasion. Previous day, this matter was previously mentioned by Mr. Mojumdar, Lordship.
Your notice today. Where is your notice?
Lordship,
How will they come to know?
Lordship, after file, I shall give
That is
notice
not the
to
procedure. এটা কি গো?
Lordship. This is very urgent, Lordship, because the examination is going to be held on
We are
11th.
asking you a simple thing. We told that we give a notice, make it aware, let the court be aware, others be aware. Otherwise, it cannot be
I
done.
apologize, Lordship. I will notify everyone, Lordship. Kindly take up this matter.
The notice given that you have mentioned and it will appear, we will not take up the matter tomorrow.
Lordship,
File the application, give the number. You have to file the application.
Lordship.
So give the, yes. Go back.
May I be permitted to mention, my lord, one application? I'm mentioning upon notice, my lord.
Group 2.
Group
Group
2
two.
application, my lord.
Was it hard earlier?
Yes, my lord. I guess it is hard earlier. I'm not properly instructed, my lord. Is it hard or not? But it's the application.
You don't know whether it was hard.
No, my lord.
Slipটা নিয়ে নাও দেখে নাও।
Your Lordship, may I be permitted to
Grateful, my
mention? Group 8 matter, the file is lying at court number 16 for inclusion, Your Lordship.
Application
Yes, sir.
or final hearing?
For application.
Give this. You
My lord-
gave notice. Where is your notice?
Your Lordship,
Give a notice and come back.
for inclusion,
Right.
Your Lordship.
It is ascertain whether is it a fresh application? It was
It's
hard
a
earlier.
fresh
You just now said that
application.
was it
It's an
hard
application.
earlier?
I'm not instructed on that.
When was it filed? Application?
Court number 16, the file is lying.
Court number 16, the file is whether anybody appeared for the respondents.
Your Lordship, I'm not aware of it.
So please be aware and mention, ascertain, give a notice, come back and tell us on Monday. Yes.
My lord, non-prosecution, my lord.
এই দেখো ইন পার্সনটা কি বলছে।
মাই লর্ড, আমি মোহাম্মদ শামীম, মালদা থেকে ইন পার্সন পিটিশনার। আমার এই কেসটা আগে উঠার ছিল, কিন্তু অন্য বেঞ্চ থেকে এখানে না আসে, এটা উঠেনি মাই লর্ড, ওই জন্য মেনশন করছি। একটা ডেট দেওয়ার জন্য।
অ্যাডভোকেট সাহেব আছেন? আপনার অ্যাডভোকেট সাহেব আছেন?
না,
আপনি নিজেই ফাইল করেছেন?
নিজেই এখন। থ্যাংক ইউ মাই লর্ড।
Yes.
পুরো সারছে না। Yes.
Lord, it is a 2020 recruitment process under West Bengal Board of Primary Education, my lord. Initially, my lord, for decategorization, the 19 read petitioner moved before this Honorable High Court. That is in page 43 of my read petition. I have handed over.
Is it 2016?
2020.
Then the
2020.
court has proceeded on the basis of 2000.
That was erroneously, my lord. Thereafter, it has been corrected in the latter order.
corrected.
Yes, 25th of June 2024 order, my lord. That is, my lord, page.
Yes.
But you got it. 2020 recruitment process. On the strength of judgment passed by the Honorable Supreme Court, my lord, our candidature was not considered. Lord, and accordingly, the order was dated 29th of April.
No, what will be the ultimate?
At first, your lordship kindly sees the order dated 29th of April 2024 in my stay petition, page 12.
Yes, so that goes.
Yes.
That
Thereafter, order was corrected.
after correction, it was in there no relief can be granted.
Yes. After correction of the order, my lord, we have filed an application for review. Your Lordship kindly come the review order dated 2nd of April 2025, page 16 of my stay petition.
That is not in the memo of appeal.
That is in my stay petition, my lord. The order dated 2nd of April 2025.
Then you are preferring appeal against which order?
Lord, initially, my lord, we have preferred an appeal against the order passed by the order of review. According to the honorable,
That is not maintainable.
that is not maintainable. That's why, my lord, we come before your lordship by afresh file the appeal, my lord.
Show us the review order.
Yes, that is in stay petition, page 16. Order dated 2nd of April 2025. ঠিক আছে।
Yes. Then what happened?
That order was challenged initially, my lord, before the of this coordinate bench. According to the honorable division bench, the order is, the appeal is not maintainable. That's why this appeal has been preferred, my lord. Now, my lord, our case is this. Initially, in my read petition, or page 43 of the lordship kindly first order dated 22nd of April 24th February
No,
2022.
if the review order remains, review application or appeal against that review order has been dismissed.
Not maintainable on the ground.
Now, the review order is there. Now, how can we go back to the earlier orders? Because then the review order you have to challenge before the Supreme Court. Correct us if we are wrong. Review, an order was passed by the single bench. That was corrected. After correction, you sought for review.
Yes.
Review was disposed of.
Yes.
You were agreed by the review order. You were agreed by the review order. That is why you preferred appeal against that. Appeal court said review is not maintainable. Now, unless this review, how can we interfere with the review order?
Now, Lord, we are challenging. We have not come here against the review order, my lord. We have come here, my lord. We have come here against the correction order.
That's not review order.
Correction order dated 25th of June 2024.
Which 19 যেটা ওই যেটা স্টে অ্যাপ্লিকেশনে অ্যানোন্স করেছে which review order is at page Mr.
Page, my lord, 16. 16. Review order dated 2nd of April 2025. That is review order.
Now the review was dismissed.
Review was disposed of.
That no relief can be granted.
No relief can be granted in terms of the order passed by the Honorable Supreme Court in Ali Hossain's case. Due to expiry of the life of the panel.
Now this review order
was
after dismissal of the appeal as non-maintainable.
Yes.
This review order attains finality unless
here, my lord, we have come by challenging the order dated 25th of June 2024 by leave granted by this honorable division bench. That is, my lord, page order dated 19th of May 2025, page 17 of my stay petition, my lord. Page 17, 19th May 2025.
রিফিউজ করছে রিফিউজ হয় অরিজিনাল অর্ডারটা
একটা লিবার্টি দিয়ে রেখেছে।
Well, I am extremely sorry, I have only one copy. 9th of May 2024.
একটা কপি দর্শক যেটার সঙ্গে ওটা পেজ মিলবে না।
29-এ বলে দিল।
দুটো কপি, এটা ডিভিশন বেঞ্চে আমি
That clarification petition was
In the year 2022.
prior to May 2022.
Yes, prior to May 2022. And your present read petition in the year 2024, month of April, prior to Ali Hussain's case, my lord. An order was passed 29th of April. That order was corrected on 25th of June on the strength of this judgment, my lord.
এটা একটু স্টেপল করে দাও। Yes, Mr. Vishas, but
apart from what is fallen from your lordship, ultimately the after order of the review, the main order already reviewed. Now he has the come before your lordship,
challenging that order,
challenging that order.
the correction order.
The correction order.
Correction order. My humble submission, he should go before the Supreme Court, first.
But
Leave is granted by the division bench to move, and there is a delay. I'm just straight away answering the merit of the matter.
No.
Apart from the delay.
no, what I was thinking was review order attend finality.
Absolutely, review order
So,
attend
but
finality.
But if the review order attends finality, that does not prevent him from challenging the parent order.
Absolutely,
That is what he has done.
Present appeal.
Right. So maintainability is not an issue. Now you submit on merit.
I am no, I am on the maintainability, as well as the section 5, delay,
Why you are saying maintainability?
because the review order it reaches finality.
Right.
The order was modified.
Right.
He has to question the order of the division bench, where the review was dismissed.
No, division bench
has
granted him
granted
leave.
leave, my lord. My lord, my humble submission, my lord, even that, my lord, he has to prefer an appeal, my lord, challenging the earlier order of the division bench. Otherwise, my lord, it reaches finality, my lord.
Which earlier order?
My lord, this review order, my lord, or the other division bench.
Tell us on
My lord,
merit.
I am on merit, my lord. My lord, your lordship, kindly, my lord, do just something. My lord, this is a extract copy, my lord, just 5 minutes back, my lord, I have received it, the instruction. I could not stitch, my lord, your lordship. My lord, kindly excuse me, my lord. Just 5 minutes back, my lord, I have received it. I've got the printout.
You are not prepared.
I am prepared. I am prepared. My lord, your lordship, no, my lord.
Now, what is the story? Tell us.
My lord, I'm just, my lord, just giving, my lord. My lord, they were impaneled in
The 2020
2020 recruitment process
Very good.
under, my lord, exempted general category. Exempted general category. My lord, these 19 writ petitioners filed the writ petition. My lord, their case was I was not exempted category candidate. I was wrongfully impaneled. Whatever may be the mistake of either the board or the petitioner, that was not decided. My lord, the single bench, my lord, was pleased to direct us to decategorize him. You put him in his actual category. If he comes within the zone of consideration, you give appointment. My lord, we accepted the order. Because whatever may be the wrong on the part of the either of the petitioner or the board, my lord, we accepted the order, we corrected it. But amongst the 19, my lord, we have given appointment 12. My lord, rest 7 are before your lordship now. My lord, your lordship, my lord, have handed over. Your lordship kindly consider the first page. Before that, your lordship knows the, my lord, in the TET examination, my lord, TET is the eligibility criteria. You have to first TET, then you can only apply for the recruitment process. My lord, TET is, my lord, the qualifying marks is 90. My lord, 60% is the qualifying marks in the TET. And my lord, the 5% relaxation for ST, SC, OBC, and my lord, other, my lord, the exempted all, my lord. My lord, they declared in the TET examination that he was exempted category candidate. Somehow, my lord, he in the OMR sheet, he marked as OMR as exempted category candidate. He got 5% relaxation.
And that was also obtained by the others.
My lord, I'm just coming, my lord. I'm just coming, my lord. Your lordship kindly, for the time being, your lordship kindly, my lord, consider, my lord, 7. My lord, these 5, my lord. My lord, they got, your lordship, from the next page, my lord, the second page, your lordship will, my lord, get the score. Your lordship, my lord, I have marked it. Your lordship, kindly excuse me. That sideline, my lord, side, I have marked it. Your lordship will find Mousumi Bera. The second page. Yes. Your lordship, my lord, just I have given a mark, my lord.
Yes, yes, exempted 84.
84. My lord, this is the marks of TET.
Yes.
My lord, if, my lord, he is, my lord, exempted
TET
category
TET
candidate.
marks is how much?
My lord, 84. Mousumi Bera. My lord, your lordship, kindly see Mousumi Bera and the right hand column. Extreme right column, my lord, 84.
Marks হচ্ছে 84.
84, yes.
My lord, since he was treated as exempted category candidate, my lord, he was
5%
qualified, got 5% relaxation. Initially, my lord, the after 5% relaxation, 82 was the, 83 was the, my lord, cut-off marks. Ultimately, order of this our court, my lord, it was reduced to 82. It is Shorana.
So 82, so if he is given 5% relaxation, he was given 5%
5%
relaxation,
relaxation,
and
he declared pass. My lord. Then, my lord, he applied for the recruitment process.
Yes.
But if he was not given the 5% relaxation, my lord, it would have been, my lord, 90 is the, my lord, the pass marks. 90. The 60% of the TET. My lord, your lordship kindly consider 84. My lord, he himself, my lord, declared, or my lord, came before this honorable court, said he is not exempted category candidate. So therefore, his basic qualification, qualifying the TET, goes. So therefore, he is not a TET qualified candidate. my lord, if he is considered as
He claims himself to be the unreserved category.
is a general category, only general, not exempted. If he is a general, he has to qualify, my lord, TET by obtaining 90 out of 150. That is the 60% in, my lord, as per the NCT
That
rules.
was brought down, you said?
That was, my lord, I said
60%
of 150.
150.
150 of 60% comes to, my lord, 90.
Acha.
My lord, I said 50% initially, my lord, board
No, no,
considered
very good.
80,
150. So he got 84.
84. So
Now
therefore,
you said that the cutoff
I
was
just no, not cut off. I said, my lord, initially when the board qualifying the exempted category or my lord, reserved category,
if 5% relaxation was given, his marks becomes how much?
my lord, he got 84 in the TET.
84 he got.
My lord, initially we declared the reserved category candidate 83 pass marks. TET.
In
83
exempted category.
exempted. All reserved category. 5% relaxation,
So
83.
83 was the cutoff.
83 initially. After that, my lord, 82.
So he
Right now,
comes,
82.
so he comes within the zone.
If he is treated as exempted category candidate. Now he is saying he is not at all exempted
Understood.
category.
Understood. Now
So therefore, he is not, basic qualification goes. Malad, he is unqualified in TET. If he is unqualified in TET, he cannot apply in the recruitment process.
5% relaxation.
5% অর্থাৎ তখন ও exempted category
না,
benefit
তাহলে 5% relaxation of what?
As exempted category candidate.
That is 5% relaxation of what? Cutoff or the
Qualifying marks.
qualified mark. 90
So
Malad, 90 comes to Malad 82. Malad, for reserve category, 82 is the qualifying marks. For general category, 90 is the qualifying marks.
yes,
Malad, therefore, Malad,
90% pay থাকবে। So ওর তো 80 relaxation pay 84%.
five I have annexed. Malad,
yes, we have seen all are below 90.
all are below 90.
All are below 90.
So therefore, Malad, he is not getting 5% relaxation and he is not qualifying the TET. Malad, other 12, their marks were above Malad and they, yes, they were qualified TET. And my lord, they were
Others were, no, all these 13,
12.
12 candidates were
12 candidates were considered, they came within the zone of consideration. That is why they were given appointment. But here, for these 5,
total was what? 19.
19.
Total 19.
Total 19 came.
TET 9.
Total 19 came,
Total 19. Huh?
out of which you have given appointment to 12.
That my learned friend is
It is
saying
12.
12.
Hmm.
Now 5 is before your lordship.
Yes.
My lord,
Then if you apply this rider, those appointed candidates also are not required to be considered.
Yes.
Those, the 12 candidates.
no, their case is not now before your lordship. My lord, he is not saying
how
that.
much did the 12 candidates?
Definitely, my lord, after my lord, more than 90. Otherwise, they couldn't have, my lord, qualify the my lord TET. And if your lordship, my lord, say for the argument, my lord, this is not the case. If your lordship consider, my lord, they were not past TET. But at the best, my lord, their appointment will go. This is not the case, not the petition. This simple case is that we
So
file.
you show us that all of the remaining persons got more than 90.
My lord, this is not the case before your lordship, my lord. Today, my lord, he is filed the appeal.
Today is the first time now they are taking the plea and we are not qualified.
My lord,
But
this
we have
question
some
never
documents.
arises. This question never arises. My lord, your lordship kindly consider. This is not my chart. This is, my lord, even today, my lord, right
we
now,
understood. Now,
it
what
is in
is
the
your
website.
stand? What is your stand?
Now thereafter,
My lord, my stand is, my lord, he is not qualifying TET, therefore he cannot apply in the recruitment process. Since he declared himself as a exempted category candidate, he was, my lord, qualified. He declared qualified. That is why he could apply in the recruitment process. He considered, he came within the zone of consideration as exempted general. He was empaneled.
But Mr. বিশ্বাস, how can you take the point now?
Yes.
That point was there in the first writ petition where 19 were directed to be appointed.
Yes, my lord, when
They are in
19
that
was
order, that is
actually,
reflected all are
Yes,
state
sir, will
qualified.
you wait?
my lord, absolutely, your lordship.
Hmm.
My lord, when we considered the 19, we have seen that the 12, my lord, within zone of consideration is coming. The code, my lord, your lordship kindly considered the order of the single
Cannot
bench.
proceed on assumption. He
No,
he
not
had a-
assumption. On the my lord, not assumption. Your lordship kindly consider once, your lordship, the single bench judgment, that decategorization order. Your lordship once.
Yes.
Page 43 of my writ petition, my lord. Petition to
Just once, your lordship.
writ petition.
Then your lordship, my lord, probably, my lord, I make myself clear, my lord.
Page 43, my writ petition.
The petitioner applied for, my lord, may I read?
Yes.
Petitioner applied for participating in the recruitment process of primary school teacher in the 2016 recruitment process. My lord, it should be 2020.
2020.
Process initiated by the West Bengal Board of Primary Education. All the petitioners are TET qualified. The erroneously mentioned their category as exempted. Learned Council appearing on behalf of the West Bengal Board of Primary Education submits that the benefit of the reservation under the exempted category cannot be allowed in favor of the petitioner as the petitioners do not belong to the said category. However, it has been submitted by the Learned Council for the petitioners that that
May be
the-
accommodated in
may be
accordance
accommodated
with their
the
respective caste
caste category and
categorization. After
after
decategorization.
decategorization,
And there is every likelihood
there is every likelihood the petitioner can be accommodated or enlisted in the list.
in the list.
In view of the said submission, the board is directed to take all steps for treating the petitioner in accordance with the respective card without extending the benefit of reservation. Your Lordship, kindly mark it. Extending the benefit of reservation merit for the exempted candidate. Steps shall be taken for decategorization of the petitioner in accordance with the recruitment rules at the earliest, but positively within a period of 3 months from the communication of this order. But after this order, my lord, we decategorized. All the 19 was decategorized. My lord, after decategorization, my lord, the 12, my lord, put their my lord, actual caste category and my lord, the medium, they came within the zone of consideration. That particular zone, my lord, before my lord, the much higher than the last cut-off candidate. That is why they, my lord, were accommodated. In that particular group, they were given appointment. After my lord 12 appointment, we found my lord these 7, my lord, if the exempted lift, my lord, or exempted was not considered as exempted category, my lord, he is not passing the TET, he is not qualifying the TET. Then how can we, my lord, consider him as my lord TET my lord, the candidate?
TET qualified.
Basic qualification goes. My lord, basic, he passed the TET on the basis of his undertaking or my lord given it that he is exempted category candidate. That is why my lord got 5% relaxation, qualified the TET. Now when my lord exempted, my lord exempted, my lord,
This is a totally new point you are arguing.
Yes.
This was never argued on behalf of the board. On
my
the
lord, this
contrary,
was,
the
my lord,
board,
since your lordship
can
last,
you show us that all the candidates who were appointed, how much marks did they get, whether they were TET
my
qualified?
lord, since your lordship is saying, my lord, I am, my lord,
We are forced to say because you are taking a new point, na?
my lord, this is not a new point.
This
This
is
is
a
in
new
the
point.
website, my lord, even today, my lord, long back, it is in the website of the board. He knew his marks.
No.
He knew his mark. If he
The-
doesn't know, my lord, if
we
he
have
doesn't,
given-
Mr. Vishwas, kindly try to appreciate.
my lord,
In 2022, when the matter was heard,
my lord,
it was a fair stand on your part.
my lord,
That yes, we will decategorize. If they come within zone of consideration, we will.
my lord.
So when you made the decategorization, that was not relating to the marks in TET. That was
My
simple.
lord, simply, my lord, we
No,
said,
you show us then, if you are taking
Moreover-
the point, please show us that the 12 candidates whom you gave appointed.
my
were
lord, this
TET
12 is
qualified.
not before your lordship today.
No. You are saying what? You are saying that as he is not TET qualified,
My lord,
question of consideration does not arise because it does not come within the ambit. His case is they have proceeded that 19% approach.
Yes.
Order was complied with in respect of 12, but not in respect of 5%.
my lord,
Now they preferred fresh writ petition. They did not go for contempt.
my lord.
Now you are telling when the
But they cannot file even the contempt. Because
very good. So you have to first show us na, that you cannot extend the benefit to him because he is secured 84, which is below 90 being the prescribed mark, 90%. If those 12% you have made a departure, then the situation becomes difficult. If you can satisfy us, yes, all of those persons, yeah, without relaxation got 90, then we can hold in your favor.
my lord, even then, your lordship,
Lord,
my lord, even then, my lord, this is will be my
Moreover,
negative
my lord,
equality, my lord.
before the honorable single bench, my lord,
In
then
this list, whether those 12% are there.
Not this, but in the website,
I do
12%
not,
are there.
my lord, I want to file exception, my lord, in this regard. This is the first time, my lord. You know, before the honorable single bench, they did not.
My lord, this is a public
No,
document. In the website, it is
Lord,
there.
we have filed an
For last 2-3
application as
years.
a general category. We have given fees rupees 200 by way of challan. Not at all, my lord, at that point of time, we have submitted application on the general category.
Doing is we will allow your section 5. So far as the stay application, he has taken a new point,
Yes.
which he says that is not a new point. However, he will disclose that in opposition to your stay application, and in reply, you deal with that statement. Only remedy which you are that your very right to be considered goes. Suppose if his content,
According to him, my lord.
according to him.
Yes.
So if you can show that this was not applied in respect of those 12% who were given, then you have a right to urge an issue of discrimination. But what is the problem is your eligibility is now.
Yes, I will place some documents where from your lordship will get it that we qualified in the 2014, my lord. I
No,
have
there
some
is no disputed.
Qualified securing 90 marks. Qualified
Yes.
securing 90 marks.
But, my lord, we have applied as a general candidate, not as an exempted candidate. We have given fees rupees 200
So
by way of
then,
challan.
Mr. Mukherjee, if you have applied as a general candidate, you must have to secure 90 marks for
Yes,
her.
yes.
So admittedly, he is showing an that
Now he is showing, my lord.
My last 3 years,
Now
it is
he
in
is
the
showing.
website.
He
Last
makes
3
an
years,
Website.
3-4 years.
If he makes an argument, we
It's
have to deal
available.
with it.
Yes, yes, yes.
Available in public document domains.
Last 3-4 years, it is in the website, my lord.
No, but
Can queue up 2025.
Grateful.
I am.
There, the recommendation for transfer has been issued by the commission. Now it has been pending before the board is concerned. Madam, kindly seize the order. Tomorrow is the date for verification of documents and testimonials. An appointment letter to be issued, I believe tomorrow itself. Mr. B. Bhattacharya is there. So madam, kindly fix the matter on next Thursday under the same heading. Madam, for this.
আমরা dispose of করে
No, kindly. Madam, we have a little.
recommendation issue, they will issue.
They will let it be madam, for our benefit also as well as the benefit of the client itself. Madam, I must be candid to you, Lord. Let it be to be mentioned on any date next week after issuance of appointment letter. Now let it. Record our submission and let it be on next Thursday or something, any date. Madam. Next page is the madam, day, tomorrow is the date fixed for verification of documents.
But verification of documents for collecting of appointment letter.
Yes.
It is a transfer. So there is no verification of documents, only collecting of
Then you will issue the appointment letter.
No, we have asked the
Oh,
petitioner,
transfer order.
transfer order. asked
Then
the
he will go to join.
Yes, she.
Come
So
to
next day also you will pray for adjournment.
No.
You will
Next
say
day after issuance of appointment letter, my client will join and I myself will submit before your lordship. Matter should be disposed of.
So commission has sent you where?
Yes, to Birati, right hand side school.
Mr. Vishwas Lanet, advocate appearing for Hey, listen, Mr. Vishas. Hey, where is Mr. Vishas?
Just 13, 20. Hey, 13.
We are keeping it on 19th.
19.
Join and come.
Obliged to your lordship.
19th.
I also am praying for. Let it be joined.
19 তারিখ।
19 under that into. Grateful. Much obliged.
Yes, Mr. Mukherjee.
My lord, this is a report, my lord.
নেই বলো নেই বলো বলো তার নেই
কিছু লেখার কি আছে? Yes, my lord.
A vacancy is not there.
My lord, vacancy is there, my lord,
Then
within the jurisdiction of the my lord DI of Kolkata, my lord. But my lord, 10C, my lord, the School Education Department has my lord transferred the on the 10C application, my lord. 10C.
bypassing your lordship, sir.
No, it is not the punishment transfer, my lord.
no, 10C order came later. First, he was recommended for transfer by the commission.
But it is for the proposal, my lord, not the my lord, not the transfer, my lord. Transfer will do it, my lord, the education department, my lord. My lord, kindly see the my lord. Page 2, my lord. The interest of the my lord education, my lord, the transfer will make.
Page 45 of the DI order.
We will come to you. Wait now. What is 12th of March 2018 government order? Paragraph 9. Oh,
Paragraph 5.
amendment পেন্সিটা কোথায় আছে
Pensita is attached.
নোটিফিকেশনে দেখতে পাচ্ছি
Notification is page 51.
না ওটা টেন্সি কিন্তু এই নোটিফিকেশনটা জিজ্ঞেস করছেন এটা
Oh, notification.
all right. Then. You are
এটা কি?
9.
এই 12ই মার্চ 2018টা কি
Yes, place your case. My brother was not there on the earlier occasion.
Page 44, my lord, the first way, lordship, kindly see the my lord's previous orders, my lord, kindly see. What is the order passed by your lord, lordship, my lord, kindly see.
We will see. You tell us the facts.
Yes, my lord, page 44.
You at last you tell what.
Yes,
we have.
page 44, your lordship, kindly see. That is the DI investigation report.
Yes.
My lord, I am not reading, my lord, entirely. My lord, prior to that, only page 45, third last paragraph. Your lordship, page 45. Therefore, in better academic interest, the teacher may kindly be transferred from Garden Ridge KC Mill High School to Adarsha Madhyamik Vidyalaya. This is the DI recommendation. The latter school is running with 1,250 students and 20 teachers, and the post of headmaster is vacant in 2022. Adarsha Madhyamik Vidyalaya is a boys' school, and the employee's ID, Alok Chaki, address of Adarsha Madhyamik Vidyalaya, such and such is running with TIC since 2022. However, disciplinary proceeding may kindly be initiated against Alok Chaki. This is the, my lord, the DI investigation report.
So that amount of rupees 2,73,000, where it is written, it has been
27 lakhs.
That has been deposited also, my lord, today's report also. That is, my lord, the paragraph 8,
All right. Then what happened? Tell us.
now after the report of
This
the
was
DI,
on 18th of July.
that is, my lord, 18th of July.
Then
Next,
what
your lordship, page 46, Secretary of the Board on the, my lord, the relying the DI's investigation
after 1 week, about one
after 1 week,
week.
recommended for transfer to the commissioner, page 46.
Not recommend.
রেকমেন্ড কেন হবে? তুমি তো এটা প্রিলিমিনারি ইনভেস্টিগেশন রিপোর্ট দিলে।
Yes.
Your lordship, kindly see page 46. In reference to the subject mentioned above, please find enclosed a photocopy of the memo dated just previous memo for your perusal and necessary action as deemed fit. The DI of school has recommended the transfer of the headmaster Sri Alok Chaki from Gardenries to Adarso. This is the, my lord, the 29th July. My lord, the after that, page 46A, Deputy Secretary of the School Education issued the letter addressed to the Chairman of the School Service Commission under section 10C of the Amendment Act that the from Gardenries to Sukchar Kedarnath Poddar High School, Barakpur. I don't know, keeping aside the board recommendation, DI recommendation, whatever. Now the on the based on the letter, page 47, Secretary of the Commission issued a recommendation, and page 48, my lord, the board issued a notification to requesting me to collect the transfer order. My lord, this has been challenged. My lord, they have sent through electronic mail, page 49. Transfer order has been sent to me. My lord, I have challenged, my lord, during the puja vacation, my lord, the school called a meeting for releasing me. My lord, entirely, my lord, the contrary to law, my lord, the contrary to the rule 16 of the management rules. During puja vacation, management committee cannot call the meeting. That is the subject matter not before the law. So, however, my lord, this order has been challenged before the learned single judge. My lord, learned single judge refused to pass an interim order. My lord, my submission was, my lord, last occasion also I have submitted. 10C, Deputy Secretary, my lord, issued this, my lord, School Service Commission issued the recommendation for transfer to Sukchar Kedarnath under section 10C. That transfer order continuing the allegations against me as per the DI investigation report, not, my lord, the administrative reasons. My lord, that is why I proposes before your lordships, my lord, earlier occasion, that since the DI has recommended Adarso, I can accept Adarso. My lord, even, my lord, my challenge was, my lord, my transfer was illegal. But I can accept the Adarso. Because the Adarso, my lord, the nearest to my residence. Also, my lord, the DI has also proposes. That is why, my lords, my lord, the earlier division has also directed that whether the Adarso, why not, I have been, will not be transferred to Adarso. Now, my lord, the DI has submitted a report.
So why you are saying that it is not on administrative reason?
Page 10.
Page 47, School Service Commission. Because the
That was also for a reason.
বলতে চাইছিল অ্যালিগেশন সেম রাইট টু রিপোর্টে অ্যাজ পার এ রেকমেন্ডেশন হচ্ছে সেম রিপোর্টে ডিসিপ্লিনারি প্রসিডিংস কি জিজ্ঞেস করবে হ্যাঁ জিজ্ঞেস করছি কি বলছি অর্ডার
এইটাতে এরিগেশনটা হচ্ছে
তোমার ইনস্ট্রাকশন বলছে তোমাকে এটাই ডিফেন্ড করতে হবে আমি যেখানে পাচ্ছি সেখানে যেতে হবে হ্যাঁ
বিভিন্ন ফিনান্সিয়াল
তার জন্য অপশন
বললো যে ওকে ট্রান্সফার করে দাও what is the administrative সেই জন্য টেন্সিটা তো নট উইথস্ট্যান্ডিং
interest of education
there and my lord initiate proceedings. That is why, my lord, I am relying the
So
Supreme Court.
why double punishment you are saying?
First of all, my lord, I have been transferred to somewhere, and next, my lord, the initiate proceedings.
Proceeding is not a punishment.
First of complete the proceedings.
Proceeding has you are saying by that recommendation, proceeding was asked to be initiated and you were recommended to be transferred.
That is exactly, my lord, the Supreme Court says no. Punishment on the allegations is malice in law. So I can rely the judgment of the Honorable Supreme Court. That can't be.
Then what do you say about 10C?
10C, my lord, on administrative reasons, my lord, I have been transferred under section 10C. My lordships, my lord, why I have been transferred on administrative reasons.
Yes.
Based on allegation of the DI, not on administrative reasons. My lord, your lordship kindly see, my lord, first, my lord, DI complaint, DI report has been submitted. Board has recommended me. Then, my lord, the Deputy Secretary issued the order of the under section 10C. Now, the Secretary of the School Service Commission under section 10C. My lord, in continuous, my lord, arbitrarily, my lord, from the date of investigating, my lord, without any proceeding. Till date, my lord, 4 months elapsed. Till date, no proceedings, no charge sheet, no nothing. Let them suspend me if the investigation is hampered. I cannot be transferred. That is why, my lord, since there is, my lord, I have also, my lord, handed over, my lord, the paper cutting. There is very difficult to discharge my duty. That is why I proposes that I can accept, my lord, apart from the litigations and law, my lord, I can accept only others. That is why your lordship recorded that. Now the DI has bypassing your lordship's order. My lord, 2 pages, my lord, several allegations and my lord,
No, he says that 10C order, I cannot do anything.
Yes.
That is his
No,
content.
my lord proposes that why that others of my lord, the DI himself, my lord, recommended me for transfer to others. Whether the vacancy is lying in others or not. They did not disclose, my lord, whether the vacancy is lying or not. DI himself said there is a vacancy. Why not others of? That is why, my lord, the shortcut, my lord, the others of, what is their problem?
London is taking 2 stands. Either he
That's true. That is true stand. My lord, this is your lordship's, my lord,
It is a difficulty.
Deputy Secretary orderটাকে কোনো এনসি ও প্রভাবিত হতে কিভাবে এটা আসলে হলো আছে না পাস করতে গিয়ে তো ওই পিআর অর্ডারটাও দেখেছে যদি অ্যাডমিনিস্ট্রেটিভ হিসেবে ইনভলভমেন্ট ট্রান্সফার দ্যাটস গুড খুবই চাইছে কিন্তু এইখানে তুমি বলছো খুব রয়েছে
It is penal.
Now, how far is this school Shukchar from your present school?
about 32 kilometers. And my lord, the 46 page, board has recommended to Adarso address to the Commissioner of School Education.
board has not.
Now the Commissioner of School Education address to the Commissioner.
Board has nothing to do.
Board
Board
has
is
recommended.
Arey Baba,
Power to recommend.
board has recommended.
not
Board
recommended.
Later argue.
Jaji,
Preliminary
Later
investigation.
argue.
please, if you repeat it, why you are saying so?
Functional lordship.
At the wrong time, you will get your touch. If you may speak in between, we get disturbed. Have mercy on us. We are doing so many matters.
Well, the page 46, board has recommended for transfer me to Adarso address to the Commissioner of School Education.
Intimation.
Page 46.
46 is an intimation to the commissioner.
What about the address to Commissioner? Next page, Deputy Secretary, same office, Deputy Secretary of the School Education Department.
Same office.
Yes, Commissioner of School Education, Deputy Secretary, has recommended to Shukchar. What is their intention? I have challenged very well. I have challenged the transfer order of Shukchar. I have challenged, my lord, under section 10C, my lord, why the transfer me, my lord, on administrative reasons. On the allegations, my lord, on the basis of the report of the DI, my lord, this transfer order also issued against me, not on administrative reasons. That is, my lord, on the report, on the basis of the, based on report of the DI.
What is an administrative reason?
No, here lordship kindly see also, my lord, the administrative reason, page, I have annexed the, my lord, the page 51 10C, 10C, my lord, the Amendment Act I have annexed. My lord, the page 51, last paragraph, notwithstanding anything contained in any other law for the time being in force or in any contract to contrary, the state government in the interest of education or interest of the public service for administrative reason may direct the commission through guideline or general instruction. Where is the guideline?
That is the government order which he has referred to in this.
No, that is also, where is the referred to?
Paragraph 10.
2018?
No, no.
Yes, I have seen that 12 March 2018.
Yes, yes.
Where is the comment?
এটা কোথায় এটাই 12 মার্চ
পাইনি, এটা যে দিয়েছে আমাকে, যা দিয়েছে আমি এটা দিলাম 12/3/2018
নম্বর এত ডিপার্টমেন্ট অফ এডুকেশন
for the interest of the education, কিন্তু তাই বলেছে
এইটা দেখতে
পাবলিক সার্ভিস অ্যাডমিনিস্ট্রেশন।
How your DI says so? Please understand. The first DI's recommendation was initiate proceeding and you transfer him to that school considering the role strength and teacher population of that school.
My lord,
After that order was passed on 16th of, that order was passed on 18th of July. Now, after about a week, in July itself, the board intimates this to the commission.
board intimates.
Board intimates. Next, after 2 months, you take a decision that on 10C, he will go and get transferred in another school. This prima facie, Mr. Mukherjee, what is the reason for issuance of this memo? There is no other reason. For administrative reason, you can. He must not be kept in that school. That was your idea. So if that is your idea, and when the vacancy at Adorsho is vacant, you are saying that no. Even if done, we will not take him to Adorsho. Then we will set aside your deputy
My lord,
secretary order.
I will recommend within the jurisdiction of the Adorsho Mahavidyalaya, my lord.
That is the DI has said.
He has said. That recommendation, my lord, submitted before the, my lord, board.
Yes.
Board on the, my lord, preliminary investigation report, my lord, to submit the, my lord, Commission of School Education, my lord.
Yes.
On the, my lord,
Very good.
paragraph 10, in the interest of education and, my lord, the interest of public service of administrative.
Mr. Mukherjee, I cannot change my reasons. When I issue the first order, your deputy secretary sleeps over 2 months. It is not that your government does not know. He issues the order under 10C after 2 months. See, order was 29th of July. Your deputy secretary suddenly wakes up and says that no, 10C I will apply, you go to another school.
18 সাথে ডিআই লিখেছি, 29 সাথে বোর্ড পাঠিয়েছে, আর ডেপুটি সেক্রেটারি ইস্যু করেছে 16 সেপ্টেম্বর। তাই পাঠিয়েছে সেপ্টেম্বরে তাতে কি
For the interest
Now, what is the, after this order was passed, what is the board's observation? Come to page 49.
49.
Page 49 টা দেখো, এবার ওই 10C order হলো তো, এবার board page 49.
This is a printed form.
It is a printed.
at that point of time,
Wait, dear. The West Bengal Commission has forwarded recommendation on 9 September 25 for transfer of following teacher in pursuance of the direction received by them from Department of School Education. Vide memo dated 6th of September. This is September, 16th of September. That is page 46. Now let us stop here. For rationalization of subject teacher in terms of notification of 10th February. This is a new ground he is taking. This is not 10C application.
That is the mistake one in the printed form. Transfer in exercise of the power. Board of Secondary Education appointment confirmation conduct and shifting of
সেটা হচ্ছে rule 3 আসুন
well, at that point of
যা
time,
wait rule 3 আসুন rule 3 টা হচ্ছে page 52 53 page 53 এরপরে আমার পরে পেন্সিল এরপরে পরের পাতাটা পরের
transfer.
Oh, এই যে rule 3
এই ক্লাস তোমার একদম 10ই ফেব্রুয়ারি 23 পরের প্যারাগ্রাফটা এই যে রুল 3 তে আছে giving recommendation অন্য recommendation ডেপুটি সেক্রেটারি খুব চালাক
Alright, friends, client my lord will accept the my lord DI proposal, DI recommendation, the others so. My lord, why he will not go to the Sukchar, my lord? Some distance are there, my lord.
why today you are saying today you are telling me be at place X after 2 months you take a decision no X is not you have to go to Y. You are sending the
Alright,
teacher from your purpose is to remove him from the school. Remove him
For the interest of student, my lord.
for the interest of the
Education.
students. And we have asked you that why
That's why, my lord, school education department, my lord, will issue the 10C recommendation.
pardon?
For the interest of education, 10C.
For the interest of education, when you are sending him to another school, your interest of education is fulfilled. Why you are throwing him to another school? Your deputy secretary, after 2 months, takes a decision that no. That he must have said that Adorsho is not will Adorsho, there is no vacancy or there is nothing. That is not the case. When you are exercising 10C, 10C was open to you after the DI passed the order. You could have said that DI order is not approval. We are in 10C changing into administering. This is another cause you are changing. It becomes prima facie penal in nature. Yes, and what is your submission, madam?
My submission is that the board issued the transfer order, my lord. At that point of time, there were two, one 10C transfer was issued and another, my lord, a rationalization was issued. That was introduced by the state government education department. At that point of time, the transfer was done in 2 ways, one by 10C, one rationalization. So, my lord, this format, I think that format has issued in that, it should have been in 10C because there are 2 formats. This has been done wrongly. But the other way, I don't have any submission because it is upon the state government to decide where to transfer, whom to transfer. Board only issues transfer order on basis of recommendation. But my lord, though it is upon the state to, they are subject to lordship, but your lordship, the DI does not have, DI can recommend for the interest of the institution for transfer, but DI cannot say take the name of a school. That is
Then
only
in
about
the
commercial
order,
school education.
then in the order, it should have been stated.
Lordship.
Unless the DI order was there, why the deputy secretary will issue the order? Why the deputy secretary issue a fresh order applying 10C? You can simply send him to that school.
No, my lord, my submission is that DI is looks after the regular running of a school. So, my lord, if a DI finds that presence of this particular person is hampering the institution, my lord, he can always recommend to transfer the person. So, my lord, but to take a name of the school, DI is not the authority to decide on the name of the school. DI can just simply forward to the education department and recommend for transfer. And it is the education commissioner of school education who has the power to decide the person to be transferred in which school under 10C. That is my only submission. So, I mean, taking the name of the DI is, my lord, is over attack on behalf of DI. That is only my understanding.
Till now, others is
DI কোনো নাম নিতেই পারে না।
করে না তো।
সেটা তুমি বলছো না তো, তোমার মক্কেল, আমি বলছি।
ও বলেছে আর আমি সেটা ডিনাই করি।
এই দুই পৃষ্ঠাতে একটা লাইনও লেখেনি আদর্শ সাথে দেওয়া যাবে
কেন লিখি?
আরে ডিআই সাথে কনসাল্ট করলে তো
ডিআই তো কমপ্লাই করি।
ভেবেছিলাম মিটিয়ে দেবো। Your deputy secretary, you had a talk?
Yes, ma'am. No, my lord. Only to DI.
We don't find, Mr. Mukherjee, why you are not sticking to Adarsh. Your deputy secretary gives no reason. That is why we requested you. Why will you suffer an order of setting aside of the order?
Others is still vacant, my lord.
Then why
further, my lord, I file
Yes.
for further. Deputy Secretary, Education Department.
So we gave you 7 days time, Mr. Mukherjee. There is a commotion going on.
Only
DI কলকাতা।
সোমবার দিয়ে দাও, আজকে বৃহস্পতিবার, সোমবার এসো।
Up and over, he can
Monday, my lord.
obtain instruction.
How many days we will?
Only
You talk to your deputy secretary and say that send him to Adarsh. Problem solved. Otherwise, suppose after, if we pass a judicial order, then in future your deputy secretary will be in problem. We do not interfere in transfer matter, but in this sort of a case, when there is a vacancy, where there is a commotion in his school, you send him to other school and she will initiate disciplinary procedure.
understand.
And page
Madam, Monday.
45, Deputy Secretary was communicated. DI communicated for others, transfer for others.
কোথায়?
Yes, page 45, address to
Deputy
Deputy
Director.
Director. That is the, all officers my lord, are sitting in the Vikas Bhavan, Commissioner of School Education. Will also page 45, address to the Deputy Director of School
Let us
Education.
solve the problem, Mr. Jan.
That I have no problem. That is why
Monday, my
from
lord.
beginning
I'll talk to.
why Monday, my lord,
Talk to
goes
Deputy
to
Secretary.
half an hour, he can take instruction.
হ্যাঁ তাহলে কি
Vikas Bhavan, over telephone.
কালকে দা
The same
Kal-
order you want, in one hand you are making recommendation of transfer. In the same order you are saying the disciplinary proceeding may be initiated.
That was a preliminary inquiry report. It is about the board to initiate proceedings.
Problem would not have been there had he not said that you
Name of the school. No,
Sir.
name of the school.
Name
There
of-
was no of the school.
Your jurisdiction of DI is to decide whether disciplinary proceeding has to. He has no right to transfer the person
No.
or recommend.
No.
Had that paragraph been not there, very good.
No.
Your deputy secretary could have said that order 10C. We wouldn't have interfered.
My lord, Monday, my lord. I'll talk to my lord.
To be mentioned Monday.
Fine.
No, Monday you have to bring your DI has to, your DI cannot do anything.
No.
Your deputy secretary who issued that order, he is to do. That you come with an order placing with a recommendation to the board that send him to Adarsh. which earlier was issued.
Gosh.
But my lord, that per as per the procedure followed, my lord.
Order may be passed, your lordship.
Order so that I can also communicate to the deputy.
May I ask
The lordship, my lord,
one point, Lord?
the
Whether court can ask anyone to send to a particular school.
previous order, my lord, it is indicated.
My lord, these
Transparency of the investigation, I think that.
my lord, the final recommendation, my lord, that has also been issued by the
Nothing to say why you are booking your.
I cannot on the
NC
behalf
or
of
NC হয়।
You
না,
are
না,
for
না,
whom?
ওটা ভুলভাল
from
কথা।
managing committee. The NC has been applied, my lord, just to.
How?
Arey, what is your problem, sir, if he goes to Adarsha?
I do not have problem, my lord.
You will throw him out of the school and you will again dictate that send him there.
My lord, they told that I have passed the, take the resolution.
So you should keep quiet. We are not setting aside. We are saying that you have to go to Adarsha. Arey, we are trying to have assistance from you. You are taking points. Ask your deputy secretary. If he doesn't, if he is so adamant, then we will appropriately deal with the deputy secretary.
Well, then an order may be passed, your lordship, directing the deputy secretary, your lordship.
That order is already there.
আজ এতক্ষণ আর্গুমেন্ট করলে এটা অর্ডার হবে না?
By an order dated, লিখুন, by an order dated 31st October 2023, we asked Mr. Mukherjee, learned advocate, এইটা কি গো এখানে দিয়েছো? আমার four. You're there, Mr. Sir. Jana, Mr. Jana.
Physical education, our pay scale, earlier your lordship had the matter when just me through that matter.
But my matter is completely different.
Chotto.
No, not my lord, the already my lord, the
No, Mr. Chotwata, is it covered by Justice?
No,
no.
Because
No.
Justice, the special bench judgment, nothing has been said regarding the physical education. Earlier, Boishali Banerjee, and that has been referred. But what is the conclusion of the special bench?
No, my lord,
Here it is a bit different.
May I tell you, lordship,
Yes.
my lord, only 2 points. My lord, the short point. GI has, my lord, initially allowed me.
Just a moment.
Baba. No, we don't understand.
Katti, এইটা দেখো তো এই can
The case 69, initially in compliance of the order of the Honorable Division Bench, GI has allowed higher scale of pay for my MPA, page 69.
Yes.
But they have, at the same time, they have filed an application for recalling of the order of the Honorable Division.
Page,
page 69.
no, you argue the matter because my lord did
Yes,
not.
that is why, my lord, I am placing that. My lord, I have, my lord, handed over a list of date with some certain enclosure.
List of dates.
Yes, list of date I have given, my lord, with certain enclosure, my lord, which have not been annexed.
এটা কোন
দিয়েছি আগে দিন দিয়েছি। I just melody. I joined in 1991 in the science and mathematics group. The proposal was made to the DI for shifting to the social science group, since I have a qualification of BPA. The DI has allowed that the DI sanction order I have annexed in my list of date, and after that I enhanced my qualification.
No, you were approved as a teacher in science group.
Science group.
Show us from the stay application, page 50.
Page science group.
BSc
Page to 49.
BSc with diploma in physical education.
BSc degree, but this is the
diploma in physical education.
Diploma in physical education, but I was probably this has not been sanction order has not been annexed. You will also kindly see list of date first annex here.
First annex. This is 26 September 1996.
Yes, I have been shifted to social science physical education group.
26, yes, shifted to physical education.
Now thereafter, my lord, I enhanced my qualification MPA, that is 2000. Yes, last date of examination 17 July 2000.
17 June.
17 June 2000. Therefore, I approached the since no action was taken, I approached this court. This on a single.
No action was taken for what? That for
postgraduate scale up, higher scale up. I approached the authority for granting higher scale up.
Then you approached the
single bench dismiss my writ petition. That is, my lord, I preferred an appeal, intra-court appeal.
No, dismiss the representation. Dismissed on what ground?
Dismiss the representation in view of the Control of Expenditure Act.
Page 61.
Page 61. Right. You will also get to yours. That has been only in view of the Control of Expenditure Act. I am not entitled.
Very good. Then you
preferred page 66. I preferred an appeal. Division may said that in view of the judgment of Souvik Ghosh, the mandatory order was passed to sanction the benefit of higher scale of page 67, second last paragraph.
Very good. Then
now the page 69, DI had sanctioned the postgraduate scale of pay subject to the final judgment of recalling filed by the state government CAN number on recording of the order of the Honorable Division. Sanction postgraduate scale. But recalling application was not listed for several years. Ultimately, I moved a writ petition for...
No, contempt you preferred.
I contempt preferred. Contempt has been dismissed. The contempt has been dismissed as the higher scale has been allowed. You will also, my lord, see the contempt order, page 70. 70. In view of compliance, nothing survives for decision on this contempt application. Even then, no benefit has been given to me. I again moved a writ petition only for getting benefit, not for granting higher scale of pay.
So your writ petition was
Page
disposed of?
77.
Page 77.
77. This learned single bench directed that the to grant the benefit in terms of the sanction order.
No, come to page 81.
No, before that, page 78 and 79.
DI 79, he says
to grant the benefit of higher scale of pay as per the order dated.
Now, needless to say, all arrear payment also need to be paid within say.
Yes.
Still on behalf of the division has undertaken to refund the additional benefit arising out of in the event the order is recalled.
Yes. Recalled or over modified. This is the single.
Then
now
what
the
happened?
State has preferred an appeal against this order.
State preferred an appeal. So that appeal was heard along with the recalling appeal.
Recalling appeal. Recalling application was dismissed.
No, before you go to that, Mr. Jana, please tell one query. Page earlier order.
Earlier
page
division?
68. Page 68.
60.
67.
67, yes.
DI was directed to give you grant scale.
Yes.
Now, needless to mention, petition will be entitled to receive payment from the date following the date of exam is deemed to be done. Now, this was past placing reliance upon Shobhik Ghosh.
Shobhik Ghosh.
That is prospective nature of control of expenditure, right? Not physical education.
Not physical education.
Achha. Now,
that is why they filed an application for recalling. Shobhik Ghosh note is not applicable to me. Recalling applications. The State has filed an.
No, why they will say Shobhik Ghosh is not applicable?
Because probably Shobhik Ghosh is not a physical education teacher. Whatever matter this Shobhik Ghosh.
Acha, then now place this is the final order passed.
This is the final order.
Page 80.
Page 80. No, recalling after the recalling application was dismissed, page 80, and appeal was heard, page 82.
No, page 81, please read.
Page 81, considering the fact
in the present appeal.
In the present appeal before us, namely Madam Such, the issue is whether the provisions of 2005 Act would be applicable to the writ petitioner in view of its improvement in qualification before the said Act came into force. Although the learned coordinate bench has referred to paragraph 14 of Shobhik Ghosh, but the learned division bench has also come to a finding that the said Act has no manner of application. It is not solely dependent upon Shobhik Ghosh, although reference was made to the said decision.
Why it is said?
Why should then probably, my lord, the Shobhik Ghosh
not solely dependent upon Shobhik Ghosh.
Shobhik Ghosh, my lord, the
Shobhik Ghosh
enhanced his qualification.
Brought Shobhik Ghosh. আনতে হবে
Shobhik Ghosh
তুমি নিয়ে আসবে না Shobhik Ghoshের সাইটেশন কত
Shobhik Ghosh পাঁচটা কেন নিয়ে আসেনি কে
এই আনাও তো 2008 ভলিউম 1 CLJ একটু লাইব্রেরিতে পাঠাও you send your clerk na 2008 volume 1 CLJ Calcutta page 810 Shobhik Ghosh
পুরো বাঁচটাই তো নিয়ে আসছি
2008 volume 1 ও তুমি পেয়ে যাচ্ছ
দেখছি আছে কিনা
you have acha please check up whether it is physical education it is not pertaining to retrospective control of expenditure act কি বলেছে ওটা what was said that is Indira Banerjee control of expenditure Justice Indira Banerjee কি বলেছিল তারপর
was Shahidullah, Shaurik and Hussain. It was allowed.
What did the court say? Give the benefit.
Shahidullah, different order. Contradiction.
Hmm.
In Shaurik and Hussain, the on the same book. In respect of.
Is it 3 judges bench or
It was referred to the larger.
refer
Decided the issue
larger bench of?
of Justice General, so mention of and
What was decided? Physical education?
physical education, see, Vaishali was upheld in paragraph and she had preferred an application following the Vaishali. Therefore, physical education is that they are just separate. You can see the Vaishali in everything. And pursuant to the Vaishali,
পাঁচটা নিয়ে না এটা
other honorable bench to pass the order following the TI commissioner also complied with those orders. In respect to the
সামনের
commissioner pass separate order.
অনেকগুলো জাজমেন্ট পরপর
That is the
অনেকগুলো
latest
কম্পারিজন করা আছে
position.
তার উপরে স্টপ ডেট করা আছে
No, we,
এই সৌভিক ঘোষ আছে
Accepted the view of the larger.
সৌভিক ঘোষ আছে দেখুন
what did the physical education differences pertaining to entry into service? If it is physical education entry, there was a 93 circular. One was a Nagpur course, whether it is full time or half time. On that,
সামার কোর্স
summer.
from Nagpur
Ultimately, for physical education, staff pattern was removed and said that even if Nagpur summer course, you will have to give.
I have those.
That clarification, the government tried to stop that. So government issued a clarification note, which was prospective in nature.
2000 also. 8 March 2000.
9th March 2000.
8 March. No, I have those.
my lords
It is an appeal, division bench appeal, justice.
Justice Standard division. And in one of the matters, your lordship, Justice Standard.
ওটা জয়ন্ত বিশ্বাস সেটাতে দুটো ডাইভার্জেন্ট ভিউ দিল সৌভিক ঘোষ এক কথা বললো আবার নির্ঝর জাস্টিস নির্ঝর সিটিং উইথ জয়ন্ত বিশ্বাস আরেক কথা বললো এটা ইন্দিরা এই ফেভারে হোল্ড করে আর জয়ন্ত বিশ্বাস বসে কন্ট্রারি তারেক চন্দ্র then what happened? It went to larger bench. Then larger bench said
Say, according to the notification from 1998 as well as 1999, all the circulars to be prevail on that date as but
prevail on which date?
from 1998 maybe 12 February. And so far as physical education teacher, since there is no entry in the honors of postgraduate, having the postgraduate degree, they are entitled. If you are plain of Vaishali, that has been upheld by the honorable. I argue before on behalf of Vaishali for the larger.
my lord I have given the judgment of বৈশালী আগের দিন সব দিয়েছিলাম পাট করে
কিছু দেয়নি আগের দিন দিয়েছি আগের থেকে চেক
yes I have given my lord the my lord judgment সব দিয়েছি তো আর কিছু ফাইল নেই
দেখো না একটু বের করে দাও দেখি একটু বৈশালীটা দাও তো একটু
দিয়েছি বৈশালী আর ওখানে দিয়েছি আগের দিন আগে
হ্যাঁ
I have given your lords to your lords দিয়েছি
One copy.
আচ্ছা
two copy
দিয়েছে বলছে
always I have given
আমি চেম্বারে নিয়ে চলে যাইনি তো আবার
Appointed in 2004, but the person 2004 postgraduate, they are just after joining, but by prior to controversy.
but I think that issues are not involved here.
no
I think that is not involved here.
that this issue my lord involved in the Vaishali that is my lord upheld by the single bench in
Acha,
my
tell
case
us now, give us the order of the DI.
Now, my lord,
Tell us
that
after the
order of the
after the Justice Sharaf's order,
they preferred an appeal.
no approval was given.
Yes, yes. This appeal, my lord, the page.
Now, prior to the DI order, prior to that,
That is the first appeal. Now the second appeal, page
no,
80.
they first appeal, they sanctioned, page 69.
Page 66.
Subject to the result, they sanctioned.
Sanction.
Uh,
Thereafter, my lord, no benefit was given. My
Then
lord,
you preferred read. Read court also said subject to you give. Now the recalling along with the appeal.
Recalling, another appeal has been filed. That appeal has been disposed of, previous appeal. Now another appeal has been filed, page.
Which was hard with can 5.
Hard with can.
And now you place that order.
Page 80. 80 is not relevant because can has been dismissed. Now 82. This is the final order of the appeal.
First place 81. First place 81.
Page, start from page.
First place 81. Recalling application which was decided.
Recalling application.
Read in the present
appeal before us, namely MAT 1455 2018. That is, my lord, against the order of Justice Sharaf. The issue is to whether the provisions of 2005 Act would be applicable to the writ petitioner in view of his improvement qualification before the said Act came into force. Although the learned coordinate bench has referred to paragraph 14 of Souvik Ghosh, but the learned division bench has also come to a finding that the said Act has no manner of application. It is not solely dependent upon Souvik Ghosh, although reference was made to the said decision. Considering the facts that the issue that need to be decided is not covered by Souvik Ghosh, there is no reason to revisit the order passed by the learned coordinate bench dated 28th September 2012.
Now
accordingly can stand dismissed. Next, now the appeal has been finally heard. Lord, may I read it, my lord? The appeal is arising out of an order dated 6 July 2018, whereby the district inspector schools was directed to immediately grant the benefit of higher scale of pay to the writ petitioner, as per the order dated September 28, 2012, in view of acquiring qualification of Master of Physical Education by the writ petitioner while working in the post of assistant teacher in work education and physical education group. The case of the writ petitioner as made out before the court of law was that he was an approved assistant teacher appointed on 11 November 1991 in work education and physical education group, having qualification of BSc and BPA. Subsequently, the writ petitioner acquired postgraduate qualification in physical education, namely Master of Physical Education from the University of Nagpur in the year 2000. It was also the case of the writ petitioner that the last date of MPA examination was 17 June 2000. After acquiring postgraduate qualification, the writ petitioner approached the concerned respondent authority for extending the benefit of postgraduate scale of pay in his favor, since he was possessing higher qualification in the relevant subject. The District Inspector School AC Kolkata, by issuing order dated 16 June 2007, held that writ petitioner was entitled to receive the benefit of higher scale of pay from the day following the last date of examination was subject to the final judgment to be passed on recalling application filed by the state. We have already considered the relevant application being can number such and such along with the appeal, which have been preferred by the state authority appellates questioning the impugn order dated 6 July 2018. While keeping the appeal pending, we dismiss the recalling application by order dated 20th September 2019. And on previous occasion, we directed the appeal to be heard on 13 January 2020. We further directed that the concerned authority of Basudepur High School to cooperate with the state authority or appellant so that the staff pattern of the said school can be placed before this court for considering the claim of the writ petitioner in the matter extending the benefit of postgraduate scale of pay. Today, the staff pattern has been placed before us, wherefrom it appears that 3 teachers were working under work education, physical education group in the said school. Name of the writ petitioner respondent Pradeep Kumar Biswas featured at serial number 2 of the staff pattern under the relevant group of work education or physical education. During the course of submission, it has been contended by the learned advocate of the writ petitioner respondent that another assistant teacher, namely Pradeep Biswas, worked under the said group of work education, has died in the meantime. And third teacher, namely Pradeep Mitra Mujumdar, has also been shifted from work education to another group. Therefore, it is submitted on behalf of the writ petitioner respondent that he should have been considered as the sole teacher under the work education physical education group. As such, the writ petitioner was entitled to receive the benefit of postgraduate scale of pay as per staff pattern. Meanwhile, the writ petitioner respondent, namely Pradeep Kumar Biswas, has superannuated and all retirement benefits have already been paid to him, considering the scale of pay which he was enjoying on the last date of his service. While examining the right of the writ petitioner respondent to get the benefit of postgraduate scale of pay for acquiring higher qualification, we find it opposite to quote amended subparagraph 3 under paragraph 12 of ROPA 98, which was brought into the effect notification dated 13 July 1999. I have bonds also, I have given to your lordships.
কি বলছে আমি বুঝতে কোন
ROPA 98 and others amendment.
Okay, 12.3 of ROPA 98.
And my lord, the page 85. On mere reading of the amendment of paragraph 12, subparagraph 3, it appears to us for extending the benefit of higher scale of pay, staff pattern of the school is a relevant consideration which escapes the consideration of the concerned state authorities as well as the learned single judge while deciding the writ petition filed by the writ petitioner hearing. Since the District Inspector of Schools AC Kolkata is the appropriate authority to consider the claim of the writ petitioner relating to postgraduate scale of pay upon considering the position of the staff pattern which was subsisting at the material point of time in the said school, we find it opposite to remand the issue back to the concerned district inspector schools for consideration upon taking note of the relevant provisions as contemplated under paragraph 12 subparagraph 3 read with amended provisions which was introduced by notification dated 13 July 1919 as quoted above. Accordingly, we direct the DI to pass a reason order relating to entitlement of the writ petitioner respondent to get higher scale of pay for acquiring postgraduate qualification in the physical education after giving an opportunity of hearing to the writ petitioner who is a retired assistant teacher of the said school as well as the said school authority which shall place the staff pattern including other relevant documents in support of the claim of the writ petitioner. While deciding the claim of the writ petitioner relating to extending the benefit of higher scale of pay, the District Inspector of Schools shall take into consideration memo dated 4th September 1998 that is the staff pattern. The aforesaid exercise shall be completed within a period of 8 weeks from the date of communication of this order. We make it clear that in view of earlier order dated 20th December 2019, in disposing can, it would not be open to the DI to deny the claim of the writ petitioner on the basis of the decision of Soubik Ghosh. Well, this is the order of the Honorable Division. Now the DI has passed a reason order, page 92. Well, the DI, paragraph 2, DI has categorically stated, you will also kindly see paragraph 2. It has been found in the staff pattern of that period of school, the assistant teacher were working, page 92. 92, this is the impugn order in the writ petition. It has been found in the staff pattern of the period of the school that 3 assistant teachers were working in work education and physical education group. Pradeep Kumar Biswas was the second assistant teacher, serial number 2. This staff pattern I have annexed in my list of names. Group. Pradeep Biswas was the first approved assistant teacher of the aforesaid group with effect from 1985 and died on 15 December 2013. Pradeep Mitra Mujumdar was the third approved assistant teacher. He has been shifted to social science group. So now the only this Pradeep Kumar Biswas alone in the group of physical education and work education.
He was still working.
No, he retired. That is the earlier division will also observed that he retired on supervision. He got the
getting pension.
Got the benefit on the basis of postgraduate scale of pay.
As by the
Postgraduate scale of pay.
when
And
did you retire?
Retired by the 30th April 2019. 30 April 2019.
Now come to DI's order, page
Yes.
9.
Next, next page, page 93, staff pattern has been quoted. You will also kindly see last third, fourth paragraph. As per GO number 670 AC dated 4th September 1998, that is the staff pattern also I have annexed in the compilation. And GO number 14 dated 8 March 1998, that is the 14 March 1998 I have also annexed. That is the qualification for School Service Commission to distribute for selection. That is what is the qualification of physical education. That is the prescribed in the notification. 8 March 1998. That I have annexed. The qualification of 2 assistant teacher in work education and physical education group must be bachelor degree with degree diploma in work education and physical education. In the present case, at the material point of time, the petitioner was the second teacher of the aforesaid group. As per staff pattern and graduate scale of pay is admissible in favor of the petitioner. Nobody was never getting a postgraduate scale of pay. Nobody was. Never. Because of the staff pattern, none of the 3 teachers was getting postgraduate scale of pay. All of them bachelor. Only petitioners acquired MPA. Now next paragraph. As per GO number 670 dated 4th September 1998, that is staff pattern, and 14 AC dated 8 January 1998.
What is this? 8 January 98?
8 January 1998, that is that is 8 January. Oh, that is I acquired the qualification from Nagpur University in summer course. That is not permissible. That has already been held.
That circular is here.
Circular, yes. I have annexed 18 March.
8th January 98.
90.
You have got 8th March 2000.
No, that is also I have annexed.
That you have annexed. 8th January 28 টা কোথায়?
No, that is করেছি 8 March 14 টা করেছি এটা কোটা No. 14 January I have annexed. Yes, 14 January I have also annexed. 14 ACB 8 January 1998. That is the procedure for selection conducted by the School Service Commission. There is a qualification prescribed. That I have annexed in my list of dates.
Then why he is saying the qualification must be bachelor and sergeant? In the present matter, petitioner was the second teacher as first tribunal. Then he comes within the fold.
The list of details.
That is the wrong. That has been wrong, my lord, the interpretation by the DI.
It is qualification.
And you will also kindly see DI, my lord, the finding, my lord, the show 155 dated 13 July 99 is not applicable in favor of the petitioner. My lord, even assuming that 13 July not applicable, because DI also saying that the 13 July 99 amendment of ROPA 98, 13 July 1999, qualification prescribed on the recommendation. That is, but I was not recommended by the school. I was not recommended by the school. That is why I said that the 13 July is not applicable. Very well.
Is not applicable.
Pradeep Biswas petitioner passed MPA in 2000 was held in June in vacation scope from Nagpur University. As per GO number such and such, the postgraduate scale of pay is not admissible in favor of the petitioner as he has not obtained such degree from 2 years regular course. This has been set aside by the learned single judge in my case. State has not prepared an appeal.
Where?
So that I am coming to that, my order. Now the
This matter.
eh?
Not in this
in
matter.
this matter,
Acha, sure.
page 94, show the order dated as per GO, no vocational MPA has been allowed, higher scale of pay, since it is not a regular course. My lord, also, my lord, the sitting singly, my lord, the passed an order. I have a copy. I have given also, my lord.
Hmm.
Now, your lordship, my lord, the single bench of that order. That is page
98.
Page 128.
You preferred this writ petition challenging the DI order.
Writ petition. Writ petition was disposed of. Two grounds. One grounds, my lord, the from Nagpur University, I acquired the postgraduate degree. Another ground, my lord, the staff pattern, or my lord, the qualifications for selection of physical education is only bachelor degree. That is the two grounds they have stated.
Page 130, kindly come. Whether GO of 8th March 2000 can be a bar. 8th March 2000 is a memo of?
Memo of, my lord, the course from the Nagpur University. That I have annexed.
You have annexed. Yes, yes.
8 March. That is also, my lord, the settled by your lordships. Another, my lord, the coordinate bill I have given also last of the time. I have a copy.
So what did the court hold?
Now the single judge, my lord, the page 132, 12, paragraph 12, in view thereof, the court is of the considered view that the matter should be regulated to the DI to decide the issue as to whether the approved staff pattern of the concerned schools permits the extending the benefit of higher scale of. Well, the staff pattern in one hand is not applicable, and also in another hand I submit that the
staff pattern not applicable, that is which circular?
670 4th September 1998. That is the, my lord.
Yes, you have given. Where is
Yes.
that again?
4th September. That is, my lord, the
4th September, where it is said that staff pattern will not be applicable in
my lord, have 4th September, this compilation, my lord, I have given.
Yes, yes.
4th September, that is page 10, 110. Yes.
Where it is said it will not apply to physical.
You will also kindly see paragraph 2 for high school.
Hmm.
D, work education, physical education, social science, 2 posts. Other category A, B, C, 2 posts within bracket, 1 pass degree, 1 honors degree. Language group, science group, social science group. Only in respect of work education, 2 posts. There is no segregation.
What is this 8198? 8198 is the
8198. This is the procedure of selection of the School Service Commission. That I have annexed, my lord, in my list of 8198. That is
so
the
you have that qualification.
I have. That is why that is qualification prescribed for bachelor degree. That is why I said, my lord, why the postgraduate scale of pay will be.
Now, why you are saying then staff pattern is not applicable in respect of?
In respect of, my lord, the 2OA. First of all, my lord, the according, even staff pattern apply, I am entitled. Nobody.
Right.
If staff pattern apply, my lord, the not apply, because, my lord, the page 10, that is the covered by the judgment of Boishali Banerjee, that has been upheld by the larger bench. That the only in the case of work education and physical education.
Where page 10, what you are showing?
That is the, my lord, the staff pattern, 4th September 1998. That is, my lord, the serial number 2.
Yes.
2D. Work education and physical education and
there shall be 2 posts.
2 posts.
As per the qualification of 98 memo.
98 memo, my lord, the.
Then why you are saying staff pattern not applicable?
Not applicable. There is no difference for past graduate or postgraduate or honors graduate.
This was said in Boishali.
Boishali, the exactly, my lord, entire, my lord, discussion was made. You will also kindly see Boishali. May I read it? My lord, the applicant was a postgraduate degree holder in physical education. She was selected for the post of physical education through the regular recruitment process conducted by the School Service Commission. After that stage, her postgraduate result was yet to be published. She was recommended to such and such school as physical education teacher as a past graduate. After declaration,
But this is concerning School Service Commission entry.
88, but the staff pattern, School Service Commission recommended on past graduate degree. She acquired master degree subsequent thereto. Vaishali division bench held that
Vaishali is in respect of persons who are entering after Commission Act 97.
I also, my lord, after the commission, my lord, not through School Service Commission, but I was shifted in 2000. That is not the Vaishali, what is the exactly, my lord, the interpretation. Paragraph, your lordship will find, paragraph 8. The case in hand is, however, having a silent feature. The applicant is a physical education teacher. There is no honors course taught by any of the universities in the state. Hence, there could be no such category in the School Service Commission in the concerned subject. Because the School Service Commission also advertisement, there is no category. We also do not find any such distinction being made in the physical education by the School Service Commission. Hence, all candidates who are having appropriate qualification in physical education are considered in one category. This is the 4th September 98, my lord, others, my lord, 2 category. Physical education in 1 category. That is the pass category. If that be the position, their subsequent acquisition of postgraduate qualification cannot be equated with any other subject. This is, my lord, I acquired postgraduate qualifications on BPEd. I am a teacher of physical education.
Acha, what is 24th June 97 circular, which I decided in this matter?
24th June 97 circular, that is, 24th June 97. That is, my lord, the through correspondence course. I have anybody, my lord, the acquired postgraduate through correspondence. Permission is to be required from the
DI.
That is not applicable here.
That is set aside also.
Set aside also, my lord, that is not applicable because that application relates to recognition of the university, not the relating to. That is the division bench also held that, my lords also. And now the learned single by has remand up again, consider the staff pattern. Only that is the issue.
Already decide ও নিজেই আগের অর্ডারটাতে বলছে যে স্টাফ প্যাটার্নে ও আওতায় চলে আসছে, জনের মধ্যে চলে আসছে। ইয়েস মিস্টার চট্টোপাধ্যায়।
হ্যাঁ, আর কি না, দিয়ে দিন তো, দিয়ে দিন কিছুই পাবে না। লার্জার বেঞ্চ খুঁজেছি।
লার্জার বেঞ্চ ছাড়া কি যাবি আর কোথাও এখন? কারণ তো লার্জার বেঞ্চই আমাদের সব। উৎপলকান্তি।
Yes, Mr. Chattopadhyay.
At best, at this stage, my lord, the special bench judgment is prevailing, and that is binding upon us regarding higher pay scale. My lord, your lordship, Tarak Chandra Koron, Roy. That is the, my lord, physical education, higher qualification, that is settled up to Supreme Court. This is not entitled.
Sure.
Now, your lordship has the larger bench judgment. I have only one copy.
Which one?
Utpalkanti Gordon. Larger bench.
Utpalkanti, yes.
I have only one copy. Can I hand over?
No, but how your argument is
on the view of the larger bench. Nothing not.
Larger bench said what? Tell us.
Larger bench upheld the Tarak Chandra Karan. Sorry, Tarak Chandra Rai. No other, nothing. Only 2-3 paragraphs, my lordship.
You read.
But I have one copy just now, and then I am reading.
Yes.
একটু দিন না ওটা নেই ওখানে লার্জার বেঞ্চটা নেই
Yes, you have given us.
লার্জার বেঞ্চ
Another copy you gave us.
আরেকটা কপি তাহলে আছে জজ সাহেবের কাছে
Which paragraph you are wanting to show?
মানে আছে আরেকটা কপি জজ সাহেব
দাও এটা আমায় দিয়েছিল আমি জানি হ্যাঁ প্যারাগ্রাফ
211 my lord at page
158.
Page my lord 158.
211.
Paragraph 12, page 158.
Yes.
Paragraph 212, last paragraph.
Achha.
Tarak Chandra Karan Supra, the question for consideration was after School Service Commission Act 1997 came into force, would appropriate appointees get the benefit of high pay scale despite being interviewed in the selected in past category?
This does not apply to him.
Yes, Lord. Now, thereafter, subsequent all paragraphs that has been discussed, Boishali and others, and Shobhik Ghosh. 211 to কত জানো? 211, 12, all are regarding the discussion.
Ultimately, what was said?
13 says the selection test only in the past category, 2013 married, 213.
Peda?
213, page 159. Same, 159. Page.
Yes, selection
This
test was
selection
only in
test,
past category.
past category.
Yes.
There was no vacancy in post or honors graduate or postgraduate teacher in the physical education.
Oh.
Got him,
No, that is
159.
not telling with my.
No, certainly,
That is
same
for
page.
another-
159. Oh, acha, acha.
So the paragraph start with the relation.
Oh, তোরটার সময় মিলছে না।
কেন ওটা
The selection, yes.
The selection test.
ওটা কি এসসি
Yes, yes.
অনলাইন
তার মানে
My lord says SCC online. I have a copy.
Yes, got it.
The selection test was only in past category. There was no vacancy in the post of honors graduate, postgraduate teacher in the physical education. Admittedly, Tarak was a postgraduate teacher, degree holder in physical science in 1998 when he participated in the selection process. For educational teachers, there was no vacancy in the post of honors graduate or postgraduate. The learned Singla dismissed the writ petition on that ground that after the Act 1997 came into force, there had been different categories for appointment or extension of benefit of higher pay scale because the government improvement of quality no more permissible. All the things are subsequently discussed with Tarak Chandra and others. Up to 238. Up to 229, that has been discussed detail.
Yes.
Thereafter, my lordship, kindly, that was subsequently all paragraphs that has been discussed.
Now, what was the conclusion?
Conclusion.
My lordship, kindly turn paragraph 238 at page 168.
Yes.
Got it, my lord?
239.
Justice Indira Banerjee, as his lordship then was, before her ladyship elevation as Chief Justice of Madras High Court and subsequent to the Honorable Supreme Court of India, authored the aforesaid judgment and the subsequent decision of Shampa Sahu Mondal Supra revisited the issue
Again, it was discussed.
It's again,
Ultimately, what was held?
now, lastly, that is my submission. 272D.
Yes.
That is paragraph, page.
Yes, 2D is your submission.
Yes. Page 186 of my.
Very confusing. Very confusing.
Larger bench pass this order. What I will do, my lord.
Has to be read with the government order dated 3rd June 2002.
Please place 2D.
We have the view that Tarok Chandra Roy Supra has been correctly decided. We are of the
What was decided in Tarok? That whoever has entered after 1997, the appointees get the benefit of higher scale of pay despite being interviewed and selected in past category. That was Tarok's view.
Yes.
So Tarok's view was upheld. Right?
Yes. As a physical teacher, past graduate.
Now, kindly come to 212. Come back to. What was the question for consideration?
Yes.
In Tarok, question for consideration was after the SSC came into force, would the appointees get the benefit of higher scale of pay despite being interviewed and selected in past category?
Yes.
He will not get.
Yes.
That was what decided in Tarok.
Yes. Because physical education is a past category subject.
Past category. This was the now. We are of the view Tarok has been correctly decided.
Thereafter, Lordship kindly for a moment 213 paragraph.
Mr.
Paragraph
Chattopadhyay, this observation itself is contrary to Boishali.
213, Lordship kindly.
Boishali has been upheld by the larger.
Paragraph 213 next, next.
Yes,
212, thereafter 213.
Hmm.
The selection test only in past category. Why, Tarok? There was no vacancy in the post of honors graduate, postgraduate teacher in physical education. So,
where you are reading?
213 paragraph.
There was no.
Admittedly, Tarok was a postgraduate degree holder, physical science, and in 1980 a participant. So, whatever may be, he is a postgraduate teacher. If he enhances qualification, he will not be entitled because physical education is a postgraduate subject.
On such consideration of division presided কি বলছে
বলেছে আরো খানিকদিন আগে
এই ভিউটা তো ইজ রং
হ্যাঁ এইটা অন সাচ কনসিডারেশন আমাদের প্রেসাইডের চিন্তা হচ্ছে সেটা হোল্ড করলো
So your argument is if Tarok had been upheld, then he is not entitled.
Because postgraduate teacher.
But to read the total, we are of the view that Tarok has to be read along with government order of 3rd June 2002. Which is that, sir?
That is the melody. I have given melody act and notification. That is melody. I tell you, ROPA 98, First Amendment 13 July, Second Amendment 3rd June.
3rd June.
Yes, 3rd June melody. That is page 8. Page, yes, page 8.
Yes. What is this? Government has the honors graduate teachers on honor, including madrasa, appointed through WBSCC. You are not appointed.
I am not appointed. That is not applicable all along. Melody either 13 July or 3rd June. That is not the relevant melody in my concern. Only staff pattern. Melody learned single judge also will remand the matter.
Mr. Chattopadhyay, kindly, our question is, anything else you want to show from this? Your contention is Tarok has been upheld. He has entered into graduate course, physical education, he cannot get postgraduate.
Repeatedly, my lord, court observed that the higher court does not create a legal right.
Very good.
Repeatedly.
Very good. Then what happens to Boishali, Mr. Chattopadhyay?
My lord, because my lord, the court observed, Boishali, my lord, that has been, my lord, upheld by the bench. And also, and not only that, my lord, if your lordship, my lord, paragraph 261, division bench, larger bench observed, when the post of which appointment is made does not require a candidate with honors or postgraduate degree, the state cannot saddle with the financial burden.
Where is that?
Paragraph 261.
In the state of West Bengal versus Ganesh Samanto?
No.
How does it
When
begin?
the post for which appointed.
When the post for which appointment, page 81 in my
One paragraph?
well, got it, page 181.
181.
Paragraph
Page-
181.
No, page 181, paragraph 261. My lord, my Justice Chatterjee,
261 starts with the state of West Bengal.
it is not my lord, because it is from the SCC.
When the
Yes, I
post for appointment, yes, when the post for which appointment is made does not require a candidate with honors, the state cannot be saddled with. In fact, candidates with honors would be overqualified. So, Tarok, in this case, it was said that I don't know, it is very confusing for me.
Confusing, my lord. I have gone through in detail now, it is very confusing. Very confusing.
Mr. Chattopadhyay, why you are relying on this? Kindly come to the stay application, the order impugned. Of Justice Hiranmoy Bhattacharya. Paragraph 7, page 147.
Two part, my lord, one, my lord,
Issue.
that part, my lord, is completed, whether the correspondence courts will be allowed.
8th March 2000. That is
That has been allowed.
That is, my lord, that is allowed by the learned single judge.
Single judge, that is not applicable because
That is,
it is
Acha, acha. And so far as approved staff pattern.
approved staff pattern.
Approved staff pattern, Mr. Chattopadhyay, for physical education, approved staff pattern will not apply.
I'm not, my lord, the staff pattern, certainly staff pattern in physical education, because only one teacher is saying there are earlier 3 teachers, now only one teacher. So I'm entitled. My question, whether you have the MPA, whether you will be entitled to higher pay scale, I'm not. I'm saying not.
Oh, I
Because in view of the larger bench.
But Mr. Chattopadhyay, if you say that, order of Justice Pranab Chattopadhyay has attained finality.
But that has also been considered. That has also been considered.
In this,
yes, special bench.
Where is the bar? Oh, you are saying Tarok Rai upheld? All nobody can get.
Yes.
272 আর 273 হবে এই যে এই ফর এক্সাম্পলটা দিয়েছে এই এক্সাম্পলের এখানে
Staff pattern
for example, a teacher joined with a postgraduate degree. During his service career, teacher enhanced his qualification claim as scale up on the basis of said degree. State claim has to be decided on the basis of the relevant rule existing at the time of acquiring his higher qualification. If he joined the school with a postgraduate degree after the government he will not be able to entitled to postgraduate scale of pay unless teacher is covered by the government order.
It's covered. উত্তর কমিশনের মারফত এনগেজমেন্ট হয়নি, তাহলে ওর ক্ষেত্রে বাট যদি তখনকার ওর সার্কুলার পারমিট করে রিজেন্ট এখন স্টাফ প্যাটার্নটা যে অ্যাপ্লাই করবে না, where is that circular staff pattern will not apply in respect of physical education?
Page 10 of my list of my that compilation, circular compilation.
Yes.
10
with that circular.
2 post.
two posts.
Qualification must be such and such. So
But the
there are
other,
two
other,
posts.
other group, two posts, but
One
divided
can be
postgraduate, one honors or postgraduate.
Yes.
But
Now,
in-
Mr. Chattopadhyay, kindly come to paragraph 272. 272, my brother has shown. A. Enhancement of pay on acquisition of higher qualification during the service career is dependent upon relevant rules operating at the time of acquisition of higher qualification and cannot be claimed as a matter of right in the absence of rules. Now, for example, a teacher joined with postgraduate degree and during his service career, teacher enhanced his qualification and obtained higher scale on the basis of the said degree. The said claim has to be decided on the basis of the relevant rules existing at the time of his acquiring such qualification. If he has joined the school with a postgraduate after 12th February 99, he would not be entitled to postgraduate scale unless he is covered by the circulars of such and such and such. Any other interpretation would encourage a backdoor entry. A teacher upon acquiring can always complete in the, then again in view of Tarok, it has proceeded. So it says Tarok is upheld in respect of a person who has entered into service prior to School Service Commission Act, as in this case. His case will be guided by the circulars.
Review of the ROPA 12(3), my lord.
তাহলে in that case he becomes entitled.
Tarok is also before School Service Commission Act.
Tarok is?
Tarok Chandra Roy. That is upheld by the larger bench.
Tarok's entry was in through School Service Commission.
No. Tarok Muslim.
Yes, that is quoted in your judgment. Paragraph 211. এই যে paragraph 200 and
appointees, not Tarok. Not Tarok, not. So Tarok Malay joined in 1999.
হ্যাঁ কমিশন চলে এসেছে।
Automatically, my lord, 12(3), my lord, in subject or group. That is, my lord, now come.
But Mr. Chattopadhyay, Tarok, this judgment in Utpal Kantikaran does not stand in the way. There are two divisions, one after commission, before commission. So after commission, if Tarok's view is upheld, then nobody can get postgraduate scale of pay in physical education. Because in physical education, there is no entry. But
Because physical education is a postgraduate.
Yeah.
Not it is the honors and
PG category.
Yes, PG category.
The physical education, there
The
is
government's view is on
arts and postgraduate category.
Yes.
All category would be postgraduate.
Yes.
অনার্স এন্ড অন্যগুলোতে কি আছে, অনার্সে যদি থাকে সে পোস্ট গ্রাজুয়েট ডিগ্রি অ্যাকোয়ার করলে পেয়ে যাবে।
মানে এটা হচ্ছে 1997 এর পর থেকে এটা ভাগ দেওয়া হলো যে who joined only in honors and postgraduate, if he improved his qualification in the subject relevant to his teaching, then only he will get a higher scale of pay. Utpal Chandra Kaur. But who, being recommended by the School Service Commission, was appointed in postgraduate category, he will not get.
Will not get any benefit.
He will not get.
সেটা contrary to Boishal.
And who joined prior to promulgation of
2005 Act.
School Service Commission Act, then his case will be decided on the basis of extant rules.
His entry was prior to School Service
Yes.
Commission.
Well,
Then the court's view is
If you-
as per the relevant rules.
His case value will be favored under the 12C, otherwise not.
Under
12C of the ROPA. 12(3).
All
ROPA.
teachers, all teachers.
All teachers, subject or group. Otherwise, my lord,
First paragraph, first page.
Where is
12(3), I have given the compilation. 12(3), page
including physical.
5.
Hmm.
Page 5.
আমি বাতাবো
all
ওই যে রোপা 98.
all teachers included.
সেটা তো পড়ে যাচ্ছে।
তাহলে উৎপল কান্তিকরণ will not be applicable here.
Not applicable.
And Tarok, if
No, also
Tarok
not applicable.
was appointed on the basis of recommendation of 1997, Tarok will also be not applicable here, and his case will be governed as per 12(3) of ROPA.
only that is the way. This judgment is very confusing.
To read it intently.
So many
Actually, we all are reading from this portion, from this.
Top to bottom, we are not.
We are not reading the entire.
And
All
of the larger bench, the another division bench presided over by the Honorable Justice Harish Tandon, also my lord, the one of the member of the larger
member of the
decided that physical education teacher is entered.
Is
Physical education teacher is entered.
even after 1997.
Yes.
discussion হলো বুঝছি।
এটা শোনেন। এটা করি।
Yes, 11 paragraph page.
Utpal Kanti is judgment dated
Judgment date
23rd December. Decided on 7th February 24. এটা কবে? আচ্ছা, which paragraph?
and which Utpal Kanti Karan also has been considered, and that has been that is paragraph কোথায় আমি আমারটা কোথায় সব দাগ দেওয়া ছিল তার
This is BSc Bio.
BSc Bio.
Where you also answered the
কি এ বকুল সিং তো না 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 BSc Bio না আরে বাবা না না এটা ফিজিক্যাল এডুকেশন তো
বৈশালী ব্যানার্জি মালার
ফিজিক্যাল এডুকেশন
হ্যাঁ
ফিজিক্যাল
No, page 2, last paragraph. Respondent herein acquired graduate degree in BSc Bio.
Bio.
Pass, 1995.
BSc Bio, next page. Subsequently acquired BPA degree from Banipur under the Calcutta University.
Subsequently have a BPA degree.
And acquired a master degree to 2001 and 2, which was a regular 2 years course pursuant to the advertisement school service commission.
This is also entries pursuant to school service commission.
Also, my lord, even then, my lord, the division
Where?
Utpal
We
Kanti
find that the case of the comes under the purview of the aforesaid circular. That circular is 3rd November 2004.
3rd November 2004, also in my compilation. That is, my lord, continuation after 12/3/1998, 13 July, 3rd June 2002, then 3rd November 2004. That is, my lord, the step-by-step amended by the government that the
given in this.
I have given, my lord, on all the circular I have annexed in this compilation. I want to compilation. Yes. That is,
No.
3rd June.
How can Utpal Kanti Karan be applicable here?
The division has quoted that. Logically, my lord, the page 2. Ultimately, that a larger bench in Utpal Kanti Karan answered the reference and also wait to judgment case.
Decided, yes.
Special bench
answered the reference.
Pointer. ওটা কোড করেছে yes that has been quoted the larger bench judgment subsequently টা কোন প্যারাগ্রাফ বলো তো subsequently the said circular as indicated was revised 3rd November 2014 in the following
Come to page 3.
Page 3.
Middle of the page. After obtaining the postgraduate degree in physical education. Page. After obtaining post, a representation made to grant postgraduate rejected by what? Respondent approached, filed, single judge held. Respondent acquired in the year 2000, much prior to coming into effect of commission. The authorities cannot reject the prayer of his. আপনি ছিলেন? You are good. উৎপল কর।
No, no, no. আমি ছিলাম।
আপনি ছিলেন?
A যদিও BA pass কিন্তু was appointed as an assistant teacher in physical education.
Was appointed as assistant teacher in physical
Physical
advertisement of
School Service Commission.
এবার কমিশনের পর ও এনজিও কমিশনের পর ও তারপর অ্যাকুয়ার করলো, ও অ্যাকুয়ার করেছিল এক্সপেন্ডিচার অ্যাক্টের আগে।
কবে চাকরিতে ঢুকলো সেটাই 99 এটা অফার আচ্ছা said appointment which was duly approved in the year request was made.
তারপরে 2001 এ করেছে। মানে স্কুল সার্ভিস কমিশন অ্যাক্ট তো 97 এ।
BPA review of the judgment, we find that the case of the appellant comes within the purview of the aforesaid circuit.
Physical education 1998 এ, তারপর মাস্টার হচ্ছে 2000 2001
আমি যাচ্ছি না ওইসব। Simply তো বললাম। Simply I am not a candidate of school service commission.
Summer vacation course
That has been single bench uphold that, the also by the others coordinate bench, division bench uphold that is the permission.
When the restriction has been made, before that he completed the course.
Okay.
Larger bench where MPA discussed in Boishali Banerjee and the Bhaskar Chakraborty, in details 7 to 8.
May have been discussed, detailed, but what calls out from the judgment?
So not only that, strictly after completion of that paragraph regarding Boishali Banerjee and Bhaskar, next paragraph, it is automatically the conjunctive. Observe, in our considered opinion, acquiring higher qualification does not create a fundamental right, nor does create a vested right.
That's true.
That isn't quoted in larger bench.
But what do you say about this judge after?
I have not gone through the
আর কি দিলাম তো, কপি দিলাম।
ধরে কি করে
রিপোর্ট হয়েছে তো, রিপোর্টেড জাজমেন্ট।
রিপোর্টের জাজমেন্ট আমার অত বিদ্যা বুদ্ধি নেই। আর আমার এর থেকে বলার জায়গা নেই।
The learned advocates appearing for the
May be permitted to mention contempt application arising out of order passing in habeas corpus proceeding. Your lordships kindly remember that matter wherein your lordships are kind enough to direct the authorities to bring back matter. It was not done in spite of due communication and reminder. Contempt has been filed, my lord.
But they have gone to Supreme Court.
No, my lord, we have filed a caveat. No notice has been served, my lord. No, we were not aware. Though they have, I just gone through a newspaper report, but as because we have put into caveat, no notice was served. My lord.
You filed the caveat.
Well, we have already filed the case.
Now, you know, keep a watch on the list.
My lord.
Yes. Uploaded.
The writ petition being W
Okay.
Original side matter.
No. With this matter, I don't know.
Regarding that original side matter, it's job.
My lord, only one thing, my lord, before. Yes, my lord, only one thing, only 40 seconds I will not take before my learned advocate general, my lord, starts. Only one thing, my lord, I fully rely upon your lordship's memory, my lord. Only one thing, kindly don't take me amiss. We have filed a, my lord, no further, nothing, my lord, only one thing, my lord, kindly. My lord, there is some pressure, my lord, from, kindly consider only 40 seconds. My lord, I have moved the application CAN 27. Our writ petition is pending. If your lordship overrules this judgment, kindly consider that our writ petition is pending on the issue of rank jumping. This is the only point I would like. Yes, Shabbir. My learned senior, Mr. Ahmed. My lord, deeply. This is the only submission you can. CAN 27 is my CAN number. And my lord, this is the list of the writ petitions pending in CAN number. My lord, I can provide your lordship the list also.
Quite understand that already. Can have a similar point. Yeah. To appear for
CAN 27.
can
27
of
of 2024. 2024. And 873, my lord, in connection with MAT 873. Right?
873 of
2023.
you're giving that.
Look, a list of CAN numbers only and nothing else. If your lord. No. The identical cans I can give, and if your lordship doesn't want, I am not going to give. These are all identical cans on the same point. My lord, yes, advocate on record is my lord. She is the advocate on. Lord, I have also similar prayers, my lord. In respect of CAN number 73, my lord, arising out of. No, there are also several CAN applications, my lord, on the similar issue, my lord. Lord, I will not trouble your lordship.
Because we do not appreciate this conduct of yours. 15 advocates were heard. You were not there in the court at that time.
I'm sorry.
At closure of their arguments, we invited Mr. Bhattacharya.
My lord, I deeply bow down, my lord. Only thing, my lord, I will not trouble your lordship, my lord.
Now, when we have finished it, you are
I will not trouble your lordship, my lord. Only thing, my lord. Lord, your lordship knows this matter may go, my lord, before the apex court, my lord. Whatever is the fate, my lord. Let the CAN applications be, my lord, taken on record, my lord, so that it can be taken note of. Lord, I have given the numbers, my lord.
Wait.
My lord, these are filed in 2025, my lord.
If the dates, you don't know the date. We know that you people are not serious. To show us what is the affirmation date.
Lord, I can, my lord, give the affirmation date of one of the CAN applications.
You cannot give one you can give because you people are not serious. Now, when everything is coming down to the end of the matter, you trying to create another wave of round of submissions. This is not permissible.
No, these are all filed on 9th of June 2022.
We gave you opportunity.
Lord, I bow down.
We will not be adding all as additional of party. We will allow you to intervene and make your submission.
Lord, these are all intervening applications, my lord. But this much I'm praying before your lordship, my lord. I understand, my lord, the difficulty, my lord, this bench is facing.
Don't talk about our difficulty. There are enough patience and we are giving you outright.
I bow down to your lordship, my lord.
So you don't have to sympathize with us.
No, my lord.
No,
it's my fault, my lord. It's my fault, my lord.
এখন
Well, these are all, my lord, served upon the board, my lord. No, these are, my lord, all notice of the service, my lord.
He's the counselor.
I'm appearing, my lord.
Mr. Pratik Mukherjee.
Yes, sir.
Only one.
Yes. With me is Ms. Shoma Pal, my lord, in can number 73 of 2025.
My lord, sorry. But I have only one can, my lord. I have only one can, my lord. Can 32. My lord, may I have only one can 32, my lord. Here the applicants are TET qualified trained candidates. Only one can, my lord. My lord, my lord.
That is Mr. Dasgupta.
Yes.
ভারতবর্ষ দেখো ছোট ছোট জায়গায় আটকে
In your cases, Mr. Mukherjee.
Yes, madam.
They have filed independent petition.
ভীষণ আলাদা জরুরি
Yes, my lord. Read petition pending. No, no, read petition is pending, my lord.
Respect of all the applicants.
Yes,
You write it down. You write it down. That all the applicants have filed separate petitions and interpret. Write it down with the advocates.
may I have your lordship's
Wait.
I'm sorry
Yes, write it down with the signature of the learned advocate on it. Where is Mr. Dasgupta?
Possibly has left.
সময়টা সুদীপ্ত তো সুদীপ্তকে ডাকতে 35 নম্বর কোটে
No, just
My lord,
What head number?
my lord, my advocate on record is signing up. এটা লিখে দিলে হয়।
Yes, what is this?
Not can 32 of 2024. My lord, here the applicants are TET qualified trained candidates. 32 of 2024. Yeah, it's 73 of 2023, my lord. Here the applicants are trained, TET qualified trained candidates. Their candidature was not considered only because their result was published by the board at the belated stage when selection was completed. So, my lord, because if the fresh selection is made, my lord, our candidature is considered, we will come automatically with the chain of consideration because we are trained candidates. So many untrained candidates are given appointment. We are all trained candidates.
Out of my lord, the scope of the petition, my lord.
Is your petition pending?
No, my lord, it's application for addition of party, my lord.
Can number
32 of 2024.
required all train?
My lord.
সবাই আছে এটা
No, my lord.
Shut down. How will you come in the zone? You have not been participating. You have not
We
participated.
participated. Our result was declared belated stage. Our TET result was published by the board on the belated stage when selection was completed.
না না 82 থেকে পাস করা কেন 82 থেকে
So you could not participate.
My lord.
আমরা টেট কোয়ালিফাই টেট ক্যান্ডিডেট
Deeply applies, my lord.
My lordship.
But may I have your lordship leave to mention, my lord? No, no, no. My lord, I had mentioned this earlier. Lordships are pleased to hear this. Can 26. My lord, lordships are also pleased to direct, my lord, point out the order passed by your lordships whether I'm covered by it or not. I am covered. My lord, this is the can where, my lord, I had my lord, that has to be incorporated in my can because that was not passed in my can. I've come with your lordship's order also. But I am a trained candidate. My additional yes. Yes. My lord, this is marked. If your lordship will excuse me. Director, copy that. Copy director. My lord, I've got copies. That's right. But I had preferred an earlier writ petition, nothing to do with this process. I preferred an earlier writ petition. This court, honorable court, directed it to be considered, have been considered and declared that my higher qualification should be taken into account. My lord, kindly comes to page 6. I am covered with this. My lord, can 26.
আমাদের expedition এখনো pending।
My 15 can application for addition of parties. I have prepared a list, my lord, where, my lord, the petitioner trained candidates and TET qualified. Our merit is compromised because, my lord, those persons who are not TET qualified, they are given appointment. Even, my lord, they have not participated. Their name also not appearing in the merit list. They also are given appointment. Now, kindly see, my lord.
122 টা লিখে দিই দাও
তারা বলে দিচ্ছে
এইভাবে লিখেছে
on the last occasion, on the last occasion, and some of the can applicant filed writ petition. 4/21 of 2024, another ballot subsequent parties 2020 of 2025.
Then why you are giving other can numbers?
Well, my can application.
Your can number is what? Dipendra Chatterjee, which can?
All can application.
All can means which can?
But I mentioned, my lord, 4/21.
Kept a copy?
No.
চিরকুটটা দাও না একটা চিরকুট দাও না
Yes.
This much of sincerity is wanted.
চিরকুটটা দাও না একটা চিরকুট
You have given at rate indiscriminately so many times. You also do not know. You have not seen also. What is the date of affirmation of this?
Well, 2024, my lord, I filed, my lord, 7 to 8 can. Addition of party and to 2025.
Where is your this that this can affirmed on such and such?
Well, I can place before your lordship within 5 minutes.
Oh, that is our responsibility. You will not say.
But within 5 minutes, I shall supply before your lordship.
Yes, 5 minutes.
My lordship,
Then we will.
Yes.
may I be permitted?
The list of matters.
And
no
date of
further
filing.
we are going to hear.
No, date of
We will
filing.
cover only. What is your parent can?
Parent can, my lord, 3. That is also
Can 3.
can 3. That is allowed.
And 3
Is allowed.
No, that
Studies দেখাতে হবে না
Yes.
Then why you are mentioning?
No. 4 21, 23 of 2024. That is not allowed.
Your can. Which one you are appearing?
Well, 4 of 2024, 21 of 2024, 23 of 2024, 20. All can 24 of 2024.
By 4 o'clock, we want the list
Yes.
along with the date of
Affirmation. Yes.
Then only we will note your presence. Yes.
Lord,
Yes. Who else?
Lordship, my can numbers, my lord, similar, my lord, I have filed 9 applications in connections with MAT 3858 1358, my lord.
Party by writ petition is pending.
So you give the list along with the date of affirmation at 4 o'clock.
But date of filing is there, my lord, I'll give.
You're given.
I'd rather date of filing. Within 1 minute it will be written. I have the applications.
Date of filing ওটা দেখে বলে দাও
4, 5, and the writ petitions are also pending. Just date of করে দিচ্ছি আমি। এটা দিয়ে দাও, date of filing টা দিয়ে দাও লিখে।
মানে জাস্ট করে দিচ্ছি পুরো আমি পেয়ে
You hand over the
মানে I'll just date of filing I'll just hand over. এটা একটু রাফ আছে। হ্যাঁ বলেছি দাও না।
You have not filed it.
Madam, my writ petition is there. Pending. Same advocate on record. Writ petition is there.
পেন্ডিং আছে
Yes.
Lordship.
Yes, Mr.
Filing টা লিখে আমি দিয়ে দিচ্ছি।
My CAN numbers are 31 and 72. I am similarly situated to the clients of Mr. Shamibul Bari that I was Mr. Shamibul Bari to the clients of Mr. Shamibul Bari that I was also deprived of not getting a chance to give the examination since it was published at a belated stage.
That's it, I don't understand.
Lordship, I unconditionally apologize, but
No, I don't understand that what is your necessity in this application.
Lordship,
Necessity will arise only upon we hold it on one way or the other.
Lordship,
Your writ petitions are there.
my lord,
All your writ petitions.
my lord.
You have to give us the list. You have to give us the list stating that all petitions pending.
My lord.
Look at the applications file number is this.
My lord.
At 4 o'clock today, otherwise we are.
To mention, my lord, one thing, my lord, only one thing, just to point out your lordship. My lord,
Mr. Kabir, what is your CAN number?
Lordship, CAN number 31 and 72, my lord.
Mr. Siddiqui?
Yes.
Grateful, Lordship.
My lord, I have filed one CAN application, my lord, 105 of 2025. 105 of 2025, my lord, untrained candidate, state qualified. And after selection, he acquired the training qualification. And the applicant is in thalassemia patient. No, my lord, I have no registration. My lord, the service may be protected because he is a thalassemia patient. I have annexed the all treatment documents in my CAN application.
You are appointed.
Yes, my lord. And my lord, the applicant is also a thalassemia patient, my lord, his service may be protected. 105, 2025.
Your name, sir?
Uh,
Your name.
Praveen Maji. Praveen Maji.
Yes.
My lord,
I'm good.
Well, I have two applications adopting the submission of Mr. Kabir and
You
Mr.
have already got your chance last time. You handed over, finished. Yes.
but item number CAN 69 that relates with Milord relates with physically handicapped candidates. Additional party application
You are already appointed.
already appointed.
What is your name?
Duke Banerjee.
CAN number?
69 Milord of 2025.
9, right? In connection with 873.
Yes.
Yes. Physically handicapped candidate.
You are appointed.
I am appointed.
You are physically handicapped.
Handicapped. The number of successful candidate is
Yes.
One point in this regard, one point I would like to mention that the number of successful candidate is lesser than the vacancy. Number of successful candidate is lesser than the vacancy. Appointed. Working.
That is your case.
That is my case.
Because last occasion says that the can two applicant names and roll number or to furnish in a tabular form. Yes. And second thing is that already I handed over this my can application. All my can no, can 70's petition is pending before the single bench. So that's why I want to indicate can 70. Can 70 in respect of can 70, the applicant's petition is pending before the single bench.
Can 7 has been allowed.
No, not yet allowed. That's why I want to indicate it. Can 70's petition number, that is WPA number 13871 of 2024.
So we can tag your submission with what Mr. Bhattacharya has said.
Yes, but the thing is that now except can
70.
yes, yes, can 25.
Of 25.
Yes. The 421 applicants is there, their petition is pending before the single bench, The point, some of the point is there is create a resonating structure. That's why, I file this application, and I indicate all my can to this tabular chart, and the last occasion I handed over it also. Except can 70, it might.
Except 70.
There is no such, other applicants have no such petitions pending.
May I just indicate what are it pending?
They are the fresh applicant, This is the tabular chart of all my applicants.
70 does not have the petition pending.
70 have the petition pending.
The others don't.
Others no.
But only one submission, since I'm sorry.
Where is it? Can 70?
Yes, there is there. Oh, 70.
Where have you stated that?
No, not yet, because today is that's why I can hand it over it, the petition number by giving the petition number. Except can 70, others petition is not pending. That's my.
Except 70,
other is the fresh applicant before this court.
May I just indicate?
Just
yes, I'm sorry.
That's my instruction. Can 70 petition pending before the WPA number 13871 of 2020.
One submission, my lord, subject to lordship's kind consideration. On the last occasion, I requested that the roll numbers of the applicants in Can 3, which was moved by Mr. Bhattacharya, may be supplied to us. We also wrote, no, it's 2, 3. 3, we are talking about Can 3, Mr. Bhattacharya.
I am appearing on Can 2. I am not.
Can 3.
You appeared along with Mr. Bhattacharya.
Yes, but Can 3 is not. Can 3 is not mine. Dibyendu Chatterjee's matter.
That is not our concern.
Yes,
Can roll numbers.
Yes, sir.
We have.
I have given. I have given.
No, 2 te diyechi's to.
6.
Are 2
That was in Can
2.
That was given to.
Yes, it's already given.
We are now,
already given.
Submissions were made from in Can 3.
Yes.
No, only one thing. In Can 3, why it is so necessary, we have definite information and appointment letters that 3 of the applicants are working as primary teachers. But when we do not have the roll numbers, when we need to point out to your lordship That how many?
They do not give it. We will record
Then
content.
my lord kindly record. Yes.
My lord, the thing is that, my lord,
Yes.
We don't want any further discussion, Mr.
Yes.
Sami. We want you to give the roll number of
yes,
those.
I will inform Mr. Chatterjee, my lord, because that can.
Give it by phone
Yes,
number.
yes, I inform. And my lord, another thing is that the submission is that if a person got appointed in subsequent selection process, that does not debar him to
That our
be the
submission
challenge
we
in the
will make.
earlier.
But that submission we will make, but that disclosure of
That's it.
but
Because he is entitled to get benefit from.
can see the name.
I mean,
Well, you have not told us as to whether anybody has got appointment in the subsequent process or not.
that is not the subject matter in this.
Why will he submit that one?
Because my learned friend submits it.
He will submit many things. Turns on
But my lord, the roll only the roll numbers may be provided to us.
Before that, only my lord, your lordship kindly record. My lord, just because my lord, all the cans are, my lord, some of the cans are misleading. Because my lord, one can is mentioned just now before your lordship can 32 and 72.
stating burden upon them. We will not be giving saying that this fact has been admitted by you. This is offhand submission of applications. We will not say.
My lord, they have passed state in 2022. How can he challenge my lord 16 recruitment process?
If you make a substantive argument in reply, finish, we cover those points. Yes, Mr. Dutta.
So my lord, only that Mr. Chatterjee would be directed to.
Get hold of Chatterjee and
Very difficult.
get hold of Chatterjee.
My lord, 30 or more applicants are working.
পারলে আমাদেরই বলে তোমরা কি নিয়ে
Chatterjee আসবে না?
Yes, Mr. Yes, Mr.
But I think that my first obligation is to once again demonstrate before this court that how the writ petitioners and those who support the writ petitioners, they have stretched this proceeding much beyond the scope of the writ petition.
Yes.
But so many submissions have been made, we are completely oblivious of the scope of the writ petition. But I have placed the writ petition in my opening submissions. I will not place it once again, but please note down the paragraphs and the points once more.
Yes.
But what are the 5 or 6 facets of the writ petition?
Like your contention of the applicants in various camps, they have dragged the scope,
Including the writ petitioner,
Yes, we have taken. They have gone beyond their pleadings and prayers in the
Yes. Now, the scope of the writ petition are, according to me, 4 or 5-fold scope. First is scam in TET 2014. This is very, very important. Scam in TET 2014 is the allegation. Your lordships would find this in paragraphs 12, 16, 17 and 18. Just note down here. I'll not waste your lordship's time in placing those.
16, 17, and
18. So the fundamental challenge is to a so-called scam in TET 2014, which according to them vitiates the TET 2014. The second is, which again is contrary to the first one, is that all TET 2014 candidates are entitled to the benefits of relaxation by MHRD. I don't know how these two can go together, be that as it may. The second is that all TET 2014 pass candidates should get the benefit of relaxation of qualification granted by or allowed by the MHRD.
the submission was otherwise.
Yes.
Said that on the date of the advertisement on 26 September, the extension period was already over prior to September.
That's what
He says that the persons who participated, correct us if we are wrong, persons who participated as TET qualified teachers, in respect of them, those who came within from March to September, this period was a gap. So they cannot, they could not have availed the relaxation. So something that was.
Yes.
But I
Election periods elapsed on the month of April, and thereafter the advertisement on the month of September. So in the interregnum period, there is no such relaxation.
That is what he
Yes,
said.
yes.
That was it.
So I have an answer to that also.
Now, what is they have not argued that all TET has to.
No, that is the subject matter of the writ petition. My submission is that whether, my lord, they can stretch it beyond the pleadings or the subject matter of the writ petition.
Second point was.
Yes.
State what you are saying.
The second point is laid out in the writ petition, in the pleadings.
Yes.
The second point is, which according to me is contrary to the first point, is that all TET 2014 candidates should be given the benefits of relaxation. Yes, that is what I intend to point out. That what is the case and what is the argument?
This contention, in which paragraph do you find?
Because these are available from paragraphs 7, 8, 9, 11, 12, 20 and 21.
Please explain what did they say? All TETs are not. They are not saying that.
Yes, can you have a look, Millard?
Which paragraph tell us?
Millard, 7 onward, kindly have a look, Millard.
That your submission, all TET candidates.
Yes. Please.
Then the benefit
Yes.
of relaxation.
Please take, Millard, paragraph number 7, for instance.
Yes.
It starts at page 29 at the bottom.
Yes.
Your petitioner state that on 11/10/2015, TET 2014 examination held in West Bengal, where huge number of students appeared. It is needless to say, this sentence, it is needless to say that on the date of examination, the notification issued by the MHRD Government of India was in force, and all students who have passed or qualified in the TET 2014 should get the benefit of notification of 9/4/2015. This is the pleading. I'm showing only one paragraph. The rest of the paragraphs, Millard, which I have highlighted.
This pleading is contrary to.
The submissions are completely dehorsed.
Pleading is contrary to the submission. That,
Of Mr. Yes.
Gap period is not their case at all in the.
Right. I have an answer to the submission also.
Yes.
that I'll make.
Yes. Now, if this is, what is your answer to this? This is right or this is wrong? That they should get the benefit?
Yeah, no, there is no dispute on that. They have got the benefit. That also I'll demonstrate. But I've got twofold answer to that. The easier way to answer is that they have got the benefit.
They have
Got the benefit. But, my lord, the other way also, my lord, the qualification, the gap that they are saying, the gap was also, my lord, filled up by the circulars of MHRD, which has not been brought to your lordship's notice.
Mr. Lady or Mr.
No, no.
Hussain or Mr.
Mr. Bhattacharya is placed the 2017. Yes, yes.
Yes, where is that in your compilation that blueprinted? You know the page of that?
101. He's in his compilation, page number 101.
আমি একটা দিয়ে দেবো
দে
এবার দুটো নেই
Yes.
101 is 17 amendment.
Or we shall got it.
Yes.
Your argument. All right, Mr. Bondwal, if we forget, we will take. Yes. Yes, Mr. Bondwal.
There is an additional submission to that also. Assuming there was a gap.
So you will go to that first. So
Oh,
their argument, their
Yes.
contention was that all TET should get, that
Right.
all TET did not get the benefit.
Right.
This is other statement of theirs.
Right.
But you say that all of them got the benefit.
And that is recorded also. I'll place all those.
Yes.
But this is where the second facet of the writ petition. But the third facet is, which is very important, in respect of Millard, the relief that is granted, is that what was the writ petitioners praying or claiming?
That relief they did not take.
No. The writ petitioners were claiming parity with those who have got appointment.
Yes.
And alternatively, they say, I must be fair to the court also, alternatively, they say that if I cannot get appointment, the appointments which have been given is bad.
So their case was that there are vacancies, we have been discriminated
Right.
to give us appointment.
Right.
This was their.
Right.
So that is strengthened by the fact, according to you, that you see the prayer, there is no prayer for settlement.
Right. This your lordship would find word in paragraph 11 of the writ petition. Then there is an omnibus submission or contention raised that since 2011 there has been corruption in all selection process.
That you have argued
Yes.
corruption, etc.
Yes. This, my lords, will find in paragraphs 14 and 22.
14 and 22.
22. And the last point is that no merit list was published and there should be a direction to publish the merit list with reservation and all that. Now this merit list is for what? This is again very important. Merit list, not of the recruitment. Merit list of TET 2014. Yes. Please take. No. Kindly see the pleadings first. Then, Millard, we can go to the prayers. Please take me at paragraph 18 at page 34 of the writ petition. Your petitioner states that the board has stated in different cases filed in the High Court that so-and-so candidates were selected, but no merit list of so-and-so candidates were ever published by the board. The board should be directed to publish a merit list by disclosing the numbers obtained in written interview, reservation category wise should be published. Candidates were informed through SMS and no merit list of candidates were published, and it proves the mischief in the recruitment process. If the process was free from corruption, then there ought to have been a transparent merit list of the 2014 qualified candidates. The process was not completed in so and so, and the department is well aware of the same, and this honorable court should take notice of the same. Persons who did not qualify for TET 14 were appointed as primary teachers by the board in spite of the specific case. Steps not taken and in spite of specific case, steps were not taken, and it shows that there was corruption and illegal financial transaction while conducting the recruitment process. The department ought to have taken suo motu steps, but that was not done for the reasons best known to them. Moreover, many candidates complained that TET 2014 qualified candidates were not issued to, certificates were not issued to them. And even today, they are fighting for that. There is no delay in filing. The public interest.
But what is your answer to their repeated assertion that no panel was published?
Yes.
The answer to
Yes, yes. But on that,
these 5 points you have
yes,
pointed.
yes.
You please answer to their
Their contentions one by one. Before I go to that, please have a look to the prayers once more. My lords have gone through it.
prayer, there is no prayer for cancellation of the recruitment process of 2016.
But the matter ends over there with respect. But standards charter does not apply. My learned friend Mr. Bhattacharya has found out standard charter. Standard chartered was a case which went before a special tribunal in a suit constituted under a special law. Yes, that judgment is on a point that if one issue is before the court, not before any forum, a connected issue can be argued or can be decided. But so far as writ jurisdiction is concerned, there are umpteen number.
The answer when you
Yes.
Now you please.
Yes.
How do you answer these queries?
Yes. Now, first, my lord, I take the point of relaxation. The rule is not under challenge. I mean the recruitment rules. Please have a look to me, Lord, Rule 6, Sub-Rule 3 of the 2016 rules.
2 years time for completion of training.
Now, this completion of training has happened within 2 years. No dispute on it. Number one, in my very respectful submission, if Rule 6.3 has been complied with, the issue of relaxation or the gap, as they are trying to point out, does not remain, my lord, an arguable issue or an issue to be decided in this proceeding.
No, if this Rule 6.3 has been complied with, then also the persons cannot say that you have not conducted the session as per the procedure.
No. Please come back to Rule 60 once, my lord.
That is the argument which Mr. Pratik
Yes,
said, that NIO is judgment of our.
I'll come to that. That's why I say, my lord, I can answer this point through different modes. One of the mode is that Rule 60 itself takes care of the situation. We need not travel to MHRD. We need not address or dilate on, my lord, the gap, and then, my lord, whether they have undertaken this training. Please take me Rule 6.3.
Yes, we have taken.
Now, Rule 6 is a rule for qualification. Then what should be the qualification? The training is one of those. Now, please take 3. In the matter of appointment, priority shall be given to those eligible candidates who possess the minimum qualification as specified by NCTE and MHRD, and thereafter the eligible candidates with the relaxed qualifications specified by MHRD may be considered. And if the candidates with relaxed qualifications
We'll take it up any other day because we are out of time with the affidavit. That's why I came to say I don't want to disturb this big man.
Right. We will, please keep a watch on the list. We will keep on some other day that
We'll try and
for
complete.
the regular wage because pilot is not.
Yes, please. So I'm grateful.
But I thought the 3 PM matter will be taken up.
No, no. Total stop. You have to finish today.
Permit me to stop when I am exhausted.
No, no. You are never exhausted. Running through all the courts for the government.
Yes, that's why I get exhausted. That is the reason I get exhausted.
Not recalled. That is what you see.
Itself takes care of the candidates who take the advantage of the relaxed qualification, that you get yourself qualified within 2 years. There is no dispute that whoever has got appointed with the relaxed
So
qualification.
MHRD extended, not extended, does not matter. Yes. Now let us come to play or the way you want to.
Yes. Now, my lord, assuming, my lord, Rule 6.3 does not take care. Does not take care of the situation or the arguments that they have made. I need to, my lord, answer that also. My lord, your lordships will kindly take, my lord.
Mr. Dotto, you are saying if Rule 6.3 comply, then the court should not be looking to any other matter.
Right.
Why? Why? Why you are saying? Qualification they might have had.
Yes.
But the procedural formalities have not been followed.
But
This classification, this panel, this publication. Then what is your?
No, that those I'll take care. But I'll address your lordship on that. But please look into the relaxation aspect because
Relaxation not we understood that this MHRD relaxation is not an issue after 6.3 has been complied.
yes.
Yes.
So my lord, I skip over, my lord, that MHRD.
Yes. But Mr. Dotto, have you seen that circular which Mr. Bandyopadhyay referred to us? Compilation page 101. He said that it has been extended.
My lord, there is a circular of 6th of September 2016, 2017. 6:30
That is not September.
It's 6th September.
Yes.
But kindly read the amendment, the contention of the amendment.
Yes.
that this training alert is applicable.
Yes.
Because of this 4 years, that is why the judgment was cited by Mr. Or, but there was a training after 18 months of
18 months.
that confirmed because of the amendment and the subsequent
This was done in Sunny Abraham. That was the matter.
Javid Singh. Javid Singh.
This was considered. And no, we didn't follow you now. This reads this program will shall be only for those in-service candidates and teachers.
Who is on which date? 31st March 2015.
Type of the
That is why my submission was yeah.
without the training.
Without.
All right. Yes, Mr.
Appearing in the same compilation, page 63. That also has covered this gap in that page 63.
Yes, Mr.
Just one thing, indicate one.
Please take this circular of 6th of September. It's there on record, but just
You have given it in your compilation.
Yes, yes.
No.
আচ্ছা
You've given it in the
বের করে দিন।
একবার দেখেন
85 one thing.
ওখান থেকে নিচে আচ্ছা ইয়েস ম্যাম কত
85.
Page 85 probably.
Page 85 of the compilation.
Page 85 or 84.
84, 85.
ওটা আমার কপিটা দেন
What you are saying is
Yes. But please take me, Lord, the 4th paragraph. As per information available, with this ministry, total number of in-service untrained candidate teachers in the state of West Bengal is 2,95,670, which includes this 32,000 and all. Then, however, till date, only 24,290 in-service untrained candidates have registered at NIOS portal so far. You may also check status anytime through so and so. Further, the clarification of various queries raised by the states have been uploaded at the NIOS portal at so and so. In addition to the above, MHRD has taken various steps for the conduct of this training smoothly. NCTE has been directed to give relaxation on the following points. Teachers who do not fulfill the minimum eligibility requirement for taking admission in DL-Ed program, that is 50% in class 12, will have to join NIOS and reappear for class 12.
was the date now. This page says to allow all untrained appointed up to 10th August 2007.
Yes.
That tallies with the date which is
Yes, yes.
So up to 10th August 2070, materials on record prove that the relaxation was there. So question of reopening that issue does not happen.
There are only 2 more paragraphs of this. Please have a look to the second page. NCT is directed under section 29 that it shall provide relaxation related to the mandatory 2 years teaching experience in government recognized primary elementary schools in order to allow all untrained teachers appointed till 10th of August 2017, which is the date Gazette notification of the amendment of RTE Act to apply for DL-ED program conducted by NIOS. Then paragraph 6, numeric 6. In view of the urgency and the time-bound nature of this matter, may I request your personal intervention to ensure registration of all untrained teachers at NIOS portal by 15 September 2017 and training by 31st of March 2019 and inform me steps taken by written correspondence. This is over.
এটা দেখো এটা অনলি ওয়েস্ট বেঙ্গলকে দিয়েছিল therefore এই আনট্রেন্ডকে সবাইকে ট্রেনিং করে
So this was meant for West Bengal.
জাস্ট তলাই সি
But can you see who is it addressed to
দুশ্মনদারি
at the bottom? So and so Secretary School Education, Government of West Bengal. This with paragraph 4.
In paragraph you just now showed us in Roman 2.
Yes, Milan.
It was 10th August 2017.
Yes.
But in clause 6, the dates do not tell. Untrained teachers by 15 September 2017.
Yes. No, this is where 6th of September 2017.
না 6th of September ওইখানে যেটা দিয়েছে সেটা হচ্ছে যারা ওই আগস্টের অবধি যারা আনট্রেন্ড ছিল আর এই ডেটটা হচ্ছে এই ডেটের মধ্যে অনলাইনে পোর্টালে রেজিস্টারটা করতে
This date of which your lordships find Milan at paragraph number 6 is the date of registration for the purpose of completing the training by 31st of March 2019.
And your appointments were made prior to that.
Yes, but before August, I'll give you the date, Milan. I think it's April.
up to April 2017
But April 2017, up to April 2017 were the appointments.
হবে 2019
Explain to us
Yes, Milan.
that relaxation by the 9th April memo was till 31st of March 2016.
16.
Now advertisement came on 26 September 2016.
at that point in time.
So this gap from 1st April 2016 till 25th September 2016,
Yes.
how does this period stand condoned?
Yes.
রুলসটা আমাদের within time
First is Milan, kindly look into the date of the rules.
Of yours is you need not go into that
Right.
because 6.3 compliant.
Right. Next is Milan, this gap, whatever they call is a gap, has been subsequently Milan filled up. How? Now, this 6 September circular Milan I have placed before my lords.
সময় তৈরি advertisement clause 6
Kindly similar the date of the recruitment rules.
26 September 2016.
Right.
no
No, 2nd March 26.
That is prior to
Yes, yes. So the 2nd March recruitment rule itself provides that get it done by 2 years from appointment. But under the rules, yes. So Millard, under the rules, these people, Millard, have got the training done within 2 years.
Understand? That is your first.
Yes.
But this
But if my first argument,
is accept, no answer.
the further things are not.
Asking an answer.
Yes. Now, in respect of the further things, assuming Millard, your lordships required to go into that part. Then the 6 September circular Millard I placed before my lords, which says that whoever has not got the training, and it is West Bengal specific, that is very important.
Whoever has not got the training, yes.
Whoever has not got the training will, I mean, the NIOS has been directed to undertake this exercise of imparting the training you must get, the untrained people must get themselves registered within a particular time, and the tests are, or the training is to be completed within 31st of March 2019. But all my untrained candidates, so-called untrained candidates, were appointed by April 2017. September 2017, the MHRD takes note of all untrained candidates in the state of West Bengal, including the 2016 recruited candidates. The central government has the figures: 2,95,670 untrained candidates in West Bengal.
Yes.
Therefore, this relaxation was extended, in my very humble submission, by this 6 September circular, irrespective of my rule. 6.3.
An order was passed by this court on directing the state to proceed with the appointment procedure. That direction was given on 15th of September. Pursuant to that direction, advertisement, this recruitment notification was issued on 26th of September 2016.
Where is that portion? Proceed.
Yes, on page.
So what was the subject matter of that?
একটু জয়বীর ও আচ্ছা
তাছাড়া একটু দিতে আমার যে
কি দেখাচ্ছিস তুই?
এটা ওই কান্না
ও আচ্ছা
Yes, yes.
Page 75. But in fact, these sentences.
No. Paragraph 4 answers that.
Yes. After this only, it's a scale. Amendment and subsequent notification. Then after page 17, were amended. That requires to complete that.
Yes. Yes.
Now, my lord, this
This is over. Now what?
no, but only one thing. My lord, there is a judgment of the Supreme Court which also takes note of this. No, I think it's there on record. But it's there on record. My lord. Kindly take, my lord, 2023 SCC Online SC 1584. Jaibir Singh.
Oh yes. Jaibir Singh is Justice Gawai's.
Yes.
That is NIOS.
Yes.
Class apart. Once training done, there is a separate. That is what this.
They appointed.
Yes.
But here, my lord, the 18 months training, taking note of, my lord, 6 September circular, my lord, has been approved. There is only one paragraph, para 56. But there is another judgment also, my lord, of Rita Haldar.
They have argued that.
Yes.
You have told us para 56 we shall look into.
Well, But there is another Rita Mal, Rita Haldar Mal. But that is also below the compilation আছে না?
No, Mr. Bishop,
তাহলে অ্যাড করিস না যদি না থাকে
dustbin is there, yes.
therefore my lord this takes care of my lord the issue of that gap.
Question of panel, Mr.
Yes. Hmm? My lord, before going to that, my lord, may I, my lord, take up, my lord, the point of Mr. Bhattacharjee on the issue of implicit pleading. Standard Chartered Bank.
That you told us.
Yes. Now please have a look to the judgment once. 2006, volume 6, Supreme Court cases, page 94. আমার কাছে খুঁজে পাচ্ছি না 600টা দে আমায় দি
Each paragraph you are saying.
Yes, just give me a moment, but I think আমি তো দাগ দিলাম গেল কোথায়
কালকে পড়ছিল তো
হ্যাঁ
You are relying upon Standard Chartered versus Andhra Pradesh.
yes, but I'm distinguishing that.
Yes. Sorry.
But give me 1 minute, my lord. I've downloaded it, but I can't find it out right now. Achha. Yes.
হোয়াটসঅ্যাপ করলে বড় স্ক্রিনে করতে পারবে
হ্যাঁ ঠিক আছে এটা পড়া যাচ্ছে
Take our copy.
Yes. No, no, I've got it. Please have a look to the first paragraph. The first paragraph says these two appeals under section 10 of the Special Court Trial of Offences relating to transactions in Securities Act 1992 are against the judgment of the Special Court constituted under section 5 of the Act by which the Special Court dismissed Special Court suit number 11 and allowed miscellaneous petition number so and so which has been transferred to it. The Special Court, the claim made by the appellant, Standard Chartered Bank herein therefore are negative in dismissed suit number so and so and the application made by the Canara Bank, etc. That rest is not important. Therefore, my lord, under the special act, in a special court, a suit is dismissed, which ultimately goes before the Supreme Court. Now, kindly take para 71.
Yes.
Mr. Jethmalani rightly contended that when these admissions were placed on record formally, there was no objection by CMF to these admissions being taken on record, nor there was any challenge by CMF to the ruling given by the special court overruling framing of the aforesaid two issues. In the circumstances, he submits that it is not open to CMF to raise objection at this stage. Apart therefore, Mr. Jethmalani also relied on Order 12, Rule 1 of CPC to contend that it is open to a party at any time to give notice by his pleading or otherwise in writing that he admits the truth of the whole or any part of the case or the case of any other party. This was precisely what happened during the trial on so and so. Merely because such a situation arises, the rest of the case does not get affected and has to be tried in accordance with law. In Bhagwati Prasad versus so and so, while dealing with the argument that it would not be open to a party to sustain a claim on the ground which is entirely new or not pleaded, this court rejected the contention and held that it was the general doctrine which could not be applied irrespective of the facts of the case on hand, and observed thus. But in considering the application of this doctrine to the facts of the present case, it is necessary to bear in mind the other principle that considerations of form cannot override the legitimate considerations of substance. If a plea is not specifically made and yet it is covered by an issue by implication, and the parties knew that the said plea was involved in the trial, then the mere fact that the plea was not expressly taken in the pleadings would not necessarily disentitle the party from relying upon it if it is satisfactorily proved by evidence. The general rule, yes, the next part. The general rule, no doubt, is that the relief should be founded on pleadings made by the parties. But where the substantial matters relating to title of both parties to the suit are touched, though indirectly or even obscurely, in the issues and the evidence has been laid about them, then the argument that a particular matter was not expressly taken in the pleading would be purely formal and technical and cannot succeed in every case. What the court has to consider in dealing with such an objection is, did the parties know the matter in question, the matter in question was involved in the trial, and did they lead evidence about it? If it appears that the parties did not know that the matter was in issue at the trial, and one of them had no opportunity to lead evidence in respect of it, that undoubtedly would be different matter. To allow one party to rely upon a matter in respect of which the other party did not lead evidence and had no opportunity to lead evidence would introduce considerations of prejudice.
Yes.
Because this was exactly my submission, but in a different context. Here, the Supreme Court says that you cannot take a party by surprise. Or in other words, one party cannot take the other party by surprise. With respect, kindly permit me to say this. Here, the court has taken us by surprise. What was adjudicated was neither pleaded, and I take upon myself the responsibility to say, nor argued. Thank you, Chudu. Thank you. What are these? Now, my lord, but I've already placed this judgment, my lord. Your lordship will find this, my lord, only one paragraph, my lord, from 2010 Supreme Court. My lord, this is not a new judgment, my lord. I have placed it on record. Please take, my lord, 2010, Volume 1, Supreme Court Cases 234. But this I have placed. But apropos, my lord, Standard Chartered, please have a relook to it. 2010, Volume 1, Supreme Court Cases 234. But I have an extra copy for your lordship, my lord. I will. Yes, yes, yes.
What is the name of
Yes, name is nameটা বলতো
ভারত আমরলাল কোঠারি
ভরত অমৃতলাল কোঠারি।
which paragraph?
The 29 to 33.
All right.
Just have a look to me at 33.
We shall look into it.
May I place it? My lord? Just may I place it? My lord? Your lordship would definitely look into it. I know that. Where under 226, where those principles would not apply. Where order, my lord, 226 is an order 19 proceeding. How would judgments like Standard Chartered would apply? Where, my lord, I must, in a writ court, we come with pleading and the evidences in the form of annexures. We-
Amratlal Kothari versus Dasu Khan, Samadhi Khan, Singhji and another.
Yes.
You have referred.
Yes.
You are saying para 33.
Para 33 is very important, but before that,
29 to 34.
para 33 is why important, but 29 onwards, I would like to place. Para 33 is important because in a 226 jurisdiction, you cannot leave it on the court to mold the relief. This is very, very important. Please take para 33. Often, yes, just may I place it, my lord? Though a high court, but this is in 226, has power to mold reliefs to meet the requirement of each case. That does not mean that the draftsman, speaking about the lawyer, that the draftsman of a writ petition should not apply his mind to the proper relief which should be asked for and throw the entire burden of it upon the court. The easiest way of getting out of petitions which does not have the pleadings and the prayers by saying that the court has the power to mold the relief. So therefore, the court should mold the relief. And this is where the Supreme Court goes a step forward or a step apart from the litigants and say, or hold, that the lawyers should be careful to draft their petition. And this is a petition, my lord.
প্লেয়ার আর ওদের প্রিলিমস ঠিকই তো আছে, ওরা তো চাইছে না ক্যান্সেলেশন, ওরাও তো অ্যাপয়েন্টমেন্ট চাইছে, তাই জন্যই কনসাসলি ক্যান্সেলেশন চাই।
Well, the petitioners have made out a completely different case.
That was not their case.
Not their case.
He's answered the question of panel.
Yes, yes, I'll come to that. I'll come to that. I'll not run away. I cannot run away.
Selection committee.
Yes. Therefore, my lord, in this backdrop of pleadings, in the backdrop of the case made out, in the backdrop of everything that had happened before the court, my lord, whether, my lord, this kind of a judgment could have been delivered by, my lord, cancelling, my lord, the appointments.
Yes.
Now, my lord, on the point of rule issue, my lord, I would like to, my lord, place the judgment under appeal once more. Huh?
What will replace Mr.
Kindly see, Milord. Milord, much of your lordship's time has been, Milord, consumed in this matter.
If you're sorry for that, then stop.
No, but I have been made to, Milord.
You have read the judgment, Mr. Dotto.
Milord, it is a judgment, Milord, with my with
Argued about predisposition of the honorable.
Yes, yes.
We have taken note of.
Yes. No, but Milord,
We want your answer to the argument.
Milord, I'll answer the arguments, Milord. But Milord, Milord, please consider one thing, Milord, whether the points which have been raised, we are all entitled to raise whatever points under the sky.
Those have not been dealt with.
No, what I respectfully submit is, Milord, in the backdrop of the judgment, Milord, whether, Milord, these points can be raised so as to support this judgment. Today, what is the writ petitioner and the others who are supporting the writ petitioner doing? They are supporting a judgment where your lordship will not find who argued what. Where, Milord, there is no conclusions drawn by the Honorable Court, and abrupt, Milord, cancellation of Milord or Milord.
Such circumstances.
Yes, taking away employment. Kindly see, Milord, whether, Milord, at all your lordships will call this a judgment. Yes. Kindly permit me to, Milord, please take this judgment.
Yes.
Milord, first paragraph is, Milord, so and so have filed the writ petition and they did not get appointment. Please skip over, Milord, paragraph 2, where, Milord, rule 6 is quoted. Then paragraph 3, Milord, again refers to rule 3. Milord, kindly bear with me for some time. Kindly bear with me. But in the backdrop of whatever is argued, Milord, I need to, Milord, place it once again. Milord, through innovative arguments, Milord, blood cannot, kindly permit me to say this, blood cannot be supplied to this judgment. Yes. Paragraph 4, all these arguments I have made
You
My
have
lord,
made those
no, but my lord, there are no answers to it. Well, my argument was there is a.
that we have heard.
Could I say this? Kindly permit me to say this. My lord, placing paragraph 4 of this judgment, my lord, I had argued that the court has made a roving inquiry, but there is no answer to that. Let your lordships read for your lordships. Paragraph 4, my lord, my.
Their argument was that what more inquiry is required
Yes.
because there had been large scale corruption. Charge sheet was produced to show that there had been crores of money transaction. Facts are so explicit that whether for the end that truth should prevail. That was their argument. 165 applied, rightly applied. Truth should prevail. Court cannot on basic what should I say technical inference. Court should not be blocked from delivering a judgment with that effect, which may have the effect of cancellation of suit. That was in support of that Tripura High Court case was cited. Yes. So we have actually now their ground of challenge. There's you have argued that scope of 165 you have argued.
Yes.
All of you have argued that in what circumstances this can be applied. You cannot be a prosecutor of your that has been argued.
Yes.
Their argument is see that it has not been the court has not acted as court has dependent on these materials which were brought on record by the board itself, and as such, you should go into this without whether there was any systemic defect in the process or not.
Yes. Now, my lord,
But that your argument we have understood that not pleading, you cannot hold the relief also. We want answers to this because Mr. Bhattacharya was stressing on the issue much. That what has happened? Rule 8 not followed. No prior approval of the state government as required under Rule 7. Why? Why that is so?
Milord, first, Milord, Mr. Bhattacharya should support the judgment with the materials, whatever is there in the judgment. He is not an appellant over here. Now, please take paragraph 8. Well, what is being said that they have placed before the court, learned single judge, is in my very humble submission incorrect. Please have a look to Milord, paragraph 8, for example. From the pleadings of the petitioners, it is found that they wanted marks of the last empaneled candidates of different categories, so and so, but no such particulars were supplied and produced by the board despite direction by the court. In the affidavit in opposition of the board maintained silence in this regard. This is nothing but suppression of facts from the petitioner as well as from the court. Therefore, the system is bad. I assume for argument's sake that there is a suppression. 36,000 people will lose job. Kindly see the next paragraph. In respect of holding aptitude test, the chairman of the board in his report said that the aptitude tests were taken, but from the evidence adduced by the interviewers and the candidates, it has been proved before this court that no aptitude test was taken. In this regard, the order passed by this court on so-and-so, not challenged, is required to be quoted. Pursuant to the order passed on so-and-so, evidence of the following named teachers who took interview of some of the candidates in 2016 recruitment process for the teachers of primary schools conducted by the board of different districts, namely so-and-so, were taken up. The real question was whether aptitude test of the candidates were taken or not. Who has raised this question? But someone has to raise this question. Right or wrong, Milord, the parties have to come before the court with this case, with this argument, with this pleading. But the entire system, my lord, of pleading and arguing, my lord, goes. Then my lord, there is a table, my lord, after that paragraph, my lord, below the table, my lord, at the internal page 80 of the judgment. No question asked by the appearing parties to the interviewers. The evidences record are kept on record. The parties my lord, don't bring in witnesses. The parties do not examine, cross-examine the witnesses, and that will be a subject.
Not asked. No question asked by appeal.
Yes, why do I subject my?
No, that is a separate issue.
Please consider one thing, my lord. Do I subject myself to an irregular procedure and then try to pick
You
holes?
must have had that statement recorded in the order that I will not do this because this will go against me. Finished.
My lord, if the judge, my lord, acts as a prosecutor, and I have to. Please consider, my lord.
Basis on that, you cannot say this is a statement recorded in the order.
Yes.
You can say we were not allowed to speak, or my submission was whatever that.
Yes.
Before any court, if you want to say that, then when you are getting a statement recorded which severely affects you, or remedies are available to you.
My lord, I can get a statement recorded either through my witness by examining in chief, or, my lord, by cross-examining my adversary's witness.
Right, right. That you did not do.
My lord, because, my lord, first of all, my lord, I don't say that evidence cannot be taken by the writ court. I don't say that. In an appropriate case, if the writ court feels it can. But question is, it is whose witness?
Court's witness. We take it is court's witness.
My lord, under which provision, my lord, may I, my lord, with humble.
Court. I am a lead court holding a.
No.
Well,
My lord, then, my lord, the judge has to be examined as a witness. At least 20 judgments I'll give, my lord. Starting from 1873.
Doctor, this is like I will keep my mouth closed and I will take this point.
No, I would say in the other way, the court is, my lord, shutting my. Yes. Court is shutting me by saying that you have not asked anything, therefore everything is sacrosanct. How did the court?
Very good thought for that, and remedy is available. You cannot curse the judge. If suppose I commit a mistake, I make a statement here. You will say, my lord, you cannot record that because I have not said that.
Yes.
Yes. But I get annoyed. I say, Mr. Doctor, don't make further submission.
Right.
You say, please record that statement.
Right.
There are plenty of ways, and you are a seasoned counsel, Mr. Doctor.
No, it's a different thing, my lord. Here, my lord, the example which my lords have been giving me is what is happening every day. Sometimes happens.
That I have to agree with all.
Yes.
And you also know that you cannot win all cases. These are facts which are there.
But, my lord, this, my lord, with respect, kindly permit me to say this, my lord. This is, my lord, not the situation in our case. Our case is where your lordships ignores all the parties, calls the court officer and says, call X, Y, or Z. I'm going to examine him tomorrow. Where is this procedure laid down? Where may I ask this question to myself? What your lordships are, my lord, observing today is where, my lord, the counsels argue before the court may accept it, court may not accept it, or, my lord, the court's observation, my lord, may not be to the liking of the counsel. Then the counsel says that, my lord, your lordship is observing this. I feel that this is not the correct procedure, or I feel that I am not being allowed.
We will say, Mr. Dotto, submit such and such.
Right. Right.
But suppose I don't record.
But where I find that I am a bystander and the judge is calling the witness, the judge is examining the witness, the judge has cross-examined the witness, and they then says that, okay, do you have any other questions to ask? But 165, I made my submissions. What does the court do? The court only asks clarificatory questions. Or if the court finds that the counsel who is either examining or cross-examining has missed an important point. There, my lord, the court intervenes, puts questions. That is the scope of 165. Where is the scope under 165 to call a witness?
Mr. Dotto,
Yes, now kindly see, my lord.
reflect on his feelings now. You have argued this, we have taken note of.
My lord, rule 8, my lord, the rule 8 argument, but I'll no, my lord, may I say this, my lord? This is, yes. My lord, what has been argued, my lord, with respect, my lord, is only to divert the attention of the court from the judgment. If the judgment is a good judgment, support it through the judgment.
Yes.
Hmm? Kindly see paragraph 10. This statement, this finding at paragraph 10, who has made this allegation? Please take paragraph 14.
Yes.
But a judgment, my lord, without reference to any pleadings, any argument that the petitioners have argued this, the respondents have argued that. I think that the respondents' arguments are to be rejected because of ABCD reason. Therefore, this is my judgment. Or the petitioners' arguments are not to be accepted. Well, in the 30 places, the expression corruption is there without any material. Now, rule 8, my lord, subject to correction, is nowhere to be found, my lord, in the judgment under appeal. Violation of rule 8, I'll take up that point. It's not that. No. My lord, kindly see para 16.
Yes. Yes.
Though the relevant rule 7 of the recruitment rules mandates constitution of selection committee, no selection committee was constituted for the purpose of selection of eligible candidates and preparation of panel. It was done by one outside agency. Where does the judge get that?
That is the evidence. Yes, Pasudan company.
Well, this is not in connection with this matter at all. Yes.
Yes, Pasudan company was for TET.
My learned friends, clients should first make up their mind. Are they challenging TET 14 or are they challenging the 2016 selection?
Put that question to me. He said that it is a two-phase selection.
No, it's not that. No.
First is state, if you qualify, you apply for 2016. Yes. So, TET 14 and the subsequent processes, according to Mr. Bhattacharjee, could reflect from the records that the state proceeding and the subsequent was conducted by an outside agency, which identical bill was referred before the other division bills through which 26,000 parties were. That was his argument. So now today, if you say that no, ESPASU was only restricted to TET 2014, show us that. Because that you have not said in your affidavit in opposition. You have not said.
That's why, my lord, I wanted to, my lord, place. In fact, I placed the writ petition. If the writ petition is on X, I cannot be expected to reply on point Y. Yes.
Doctor, you forget about what Mr.
Very well.
You satisfy our point.
Very well. Now, let me, take, their best evidence.
There is no such statement, no such ground, no S-Basu, no outside agency, no prior approval, anything is not. You satisfy us that whether this S-Basu and company was pertaining to the that issue or not.
With this caveat, that this point cannot be raised, I'll answer it. জাজমেন্টের ডেটটা কত রে? এই জাজমেন্টের ডেটটা কত? 22/5, তাই তো? 12th May. I believe, Mr. Bhattacharya, has placed, the charge sheets of CBI. Please have a look to this.
No. Before that, he placed that S-Basu and company.
Everything your lordship will get from this charge sheet itself. They have done a full-fledged investigation. I'll show from there itself.
No, that would have been bypass.
You will show what, Mr. Let us understand.
What was the involvement of S-Basu as found in the investigation?
No, that.
Yes.
The ECD or contention that S-Basu was the person found responsible for date 2014 as well as 2016.
No.
So, where do we get?
Yes. Your lordship will kindly take. Just take page 70 of the bail application of Mr. Which Mr. Bhattacharya has handed up.
Page 70.
Page 7, 0.
Mr. Dotto, are you not you to answer these queries? Do you want time or?
But I'll come back on the next week. But
we want your answer to these points, which we pointed out to Mr. Sangha.
Yes. Well, I'll come back on another day. S-Basu, I can just show to your lordship 1 or 2 paragraphs.
That is page.
Page 70. এইটাকে বের করে রাখ, এই কাগজটা লক্ষিতার নোটে আছে পেজ 90, কালকে দেখা। Please take, my lord, this second last paragraph of this page. Lokhita, ওটা বের কর।
Take the point that charge sheet is tentative, trial is pending, what will happen? And again, we rely
No.
on judge.
Very well. Then kindly take this document, which is not on record.
Not on record. Why, Mr. Dotto? You got an opportunity to file an evidence for the read code.
Read code, I don't think was subject to correction. S-Basu Rai was not an issue.
Not an issue.
Not an issue. In this proceeding, S-Basu Rai was not at all an issue.
What document you are showing?
Millard, what was the role of S-Basu Rai in the recruitment process? Millard, I will place, Millard, a resolution of the board where, Millard, S-Basu Rai was.
That is November 2017.
No, Millard, it's on 4th of October 2016.
What is that?
Just have a look, my lord, একটা copy দে না। But I can hand up, my lord, in a booklet made before on the next day. I'll serve copies on my lord. আরেকটা দে।
একটা কপি দিন স্যার, একটা কপি দিন।
এই আরেকটা দে।
আবার একটা চিকলেট আমি করেছি।
No, no, you tell now what is this.
দিচ্ছে একটা
No, no, not required. Mr. Dotto, tell us now what you say.
So and so is requested to do the following jobs. What are the jobs? Arrangement for online applications for 1,25,000 TET qualified candidates and collection of fees thereof. This is the first job of, this is 6th of October.
4th of October.
I'm sorry, 4th of October 2016.
4th of October.
But this is a meeting of the board. Minutes of the meeting of the board.
We have a letter of 14 September 2016. That is page 130 of the compilation.
দেখ 130 তে কি আছে দেখ।
আর compilation.
Why? You have the compilation. Codes paper book itself.
হ্যাঁ, ও পেপার বুক।
From the documents which Mr. Bhattacharya yes. You show us that why we shall not believe this.
আপনি যেটা দেখিয়েছে বিল অ্যাপ্লিকেশন।
Starts from page 123 of the paper.
পেপার বুক বলছে তো।
Paper book which is annexed.
ওটার কোনো সত্য, ওটার কিছু এই নেই, ওটা জানি না, ওটা তৈরি করা পিটিশনার দিয়ে তৈরি করা।
Who has placed
No,
it?
no.
Board has placed it.
No.
Then
It was handed over in the read code. It was handed over by the the petitioner, the learned lawyer of the petitioner, with a spiral binding.
No.
Not on record,
No,
not
no.
by the
That's
board.
No. Are you disputing this letter?
Yeah, absolutely.
Which one? Your signature
all,
you are disputing.
My lord,
Are absolutely won't do. You have
Yes,
to
my
tell
lord.
us why you are disputing.
Yes, my lord.
Your president's signature.
My lord, your lordship is referring?
As if you are seeing for the first time.
No.
We are hearing the matter. This is already there on you.
No.
This have been
My lord,
prepared.
the page number, my lord, your lordship.
130, 131.
My lord, I'm just answering.
We are wanting an answer to the question in the argument that Esbasu was it Esbasu entrusted for both these jobs?
Yes.
Mr. Doctor,
Yes,
will
ma'am.
be taking instruction. Please, you will look into this document and make it page 131.
এটা আমাদের ইয়ে।
Hmm. 131.
There is a bunch of documents.
Yes.
Out of those, page 120, 131 subject to be corrected.
Yes, ma'am.
Proposal for online application processing for internet.
এটা 130 আমাদের ডকুমেন্টস, 130 আমাদের ডকুমেন্টস ভুলে 131 আমাদের। আমাদের
Page 130. My lord, I am trying to, my lord, place before your lordship what had happened prior to 130. What exercise was undertaken before issuing page 130.
All right.
What was done, my lord, before the issuing page 130 is that the board had held a meeting in this regard on 4th of October 2016. This is what, my lord, I intend to, my lord, place before my lord. হ্যাঁ ও আই এম সরি আফটার দ্যাট এটা দেখা না আগে
Government.
প্লিজ টেক দিস প্লিজ আরেকটা কপি দেন
That is the government price.
প্লিজ
একটা কপি দাও কপি দাও একটা কপি দাও
please take page 19 of it where this is part of the minutes
হ্যাঁ আপনি একটা সফট কপি দিয়ে
দেবো দাঁড়াও
প্রায়র পারমিট গভর্নমেন্টের প্রায়র পারমিশন রুলস তো বলা আছে ওটা দেখাচ্ছেন কিনা পাইনি
Yes, what you are saying?
Milord, in the second, fourth paragraph, the members present in the meeting, not after that, it is also submitted. Where the paragraph starting with, where the before the paragraph number 1 at page 19, at the top of that page, handwritten para 19, Milord, where there is a para 1, middle of that page, just one line above that, it is also submitted that after publication of TET 14, result on 14/9/2016, the confidential processor had been requested to do the following jobs.
Who is this processor?
Confidential processor is S. Basurai.
Government permission.
Well, it is permissible under the rules also, I'll place.
I not get the কপিটা দাও
দিচ্ছি দাঁড়া আমার কাছে নেই এই মুহূর্তে নেই না
Now, what would they do?
ওদের ইন্টারনাল আছে
Compare, Millard, this page 19 with page 130 of the paper book. Now, what was their job? Their job number 1 was arrangement of online applications of for about 1,21,000, 25,000 TET qualified candidates and collection of fees thereof. So application arrangement, collection of fees. Then 2.
এটা তো এতে নিতে অনলাইন নিতে এটা আলাদা সফটওয়্যার তৈরি করতে
On receiving the online application, arrangements made for preparation of district-wise list for scrutiny verification and viva voce interview and aptitude test along with attendance sheet and dispatch the same to the board. Preparation of list only, not to give marks, take interview, etc. as have
State 2014.
no.
Meetings I am directed to say that the results of TET 2014 announced, now the following words.
Yes, the following works was subsequent thereto.
Yes.
Now, this has got nothing to do with, Millard, the core selection process. It is, Millard, an agency which has been engaged for the purpose of doing this administrative job, not to, Millard, scrutinize or, Millard, do the assessment
এটা এক্সপায়ার নলেজ
of the candidates. I'll read this. What has been submitted before the court is as if everything was done by the S. Basurai in regard to the assessment of the candidates' marks, qualification, etc. That is not. I'll place it. Yes, this is the job that has been given. Then kindly see what will they do. On receiving, number 2, on receiving the online application arrangements made for preparation of district-wise list for scrutiny. Only the list will be prepared for scrutiny, verification and viva voce interview and aptitude test along with attendance sheet and dispatch the same to the board. But a list has to be prepared.
This clause C is post TET 2014.
Yes.
Yes. So this says that arrangements will be made by whom? The confidential processor.
Yeah.
He will make arrangement for scrutiny, verification of testimonials and viva voce sheets for necessary entry. Who is he to go into the Viva process?
Where they will only prepare the sheet, where that is the word sheet is important. They are not going to provide any marks. It's a, in a sense, it is called broadsheet. Their lordships, officers, in the after the court hours, I find they have a sheet on which they note something, how many matters taken up, disposed.
Don't bring that.
No, I'm giving an example.
That is too much.
So this broadsheet, this has to be prepared by them.
Yes.
Now, kindly see, along with attendance sheet and dispatch the same to the board. Arrangement to take up scrutiny, verification.
Your contention is Viva procedure and marks allotment was not by.
We'll all place everything before the court.
Huh?
We will place, if required, everything before the court. S. Basurai has not done anything. Only administrative job has been done.
Please show us, Mr. Dotto.
Yes.
Mr. Dotto, already you have shown this. Please show us that approval which is required under Rule 7.
Yes. Now, so far as the rule is concerned, your lordship may kindly take Rule 4, Sub-Rule 5E.
On 11th, and most probably we will take it up on 12th also. 12th we will on 12th we will resolve
Mala 12.
whatever is to be done. We said
12.
we are taking in advance.
Mala in 12 Mala another fee. Mr. Bhattacharya's another matter is fixed on 12 Mala. And here AG also, learned advocate general also be paid. Sir, SSC মামলাটা রাখলো যেটা রোল চ্যালেঞ্জের 12 তারিখ। No, Mr. Both the court number 18, court room number 18. Virus challenge of a matter. Court room number 18. Honorable Justice Sinha. Honorable Justice Sinha on 12 malad matter is fixed. Where Mr. But Dr.
But this will be in the second half.
Because if আপনার অসুবিধা তাহলে
মানে as per your lordship direction মানে I period.
My lords, I would, if I may.
হ্যাঁ টাকা করে হয়ে যাবে তবে না হলে ওরা লড়ালড়ি করে নিবে
My lords, if I may make a request. In one of the matters where I appear, I would request of my lords nothing more than 10 to 15 minutes. I'll try and confine myself in 10 minutes, and I assure you I'll be succinct and to the point in the rejoinder.
Is your advocate on record, madam?
Divanji.
My lords, it is Shubhamoy Divanji.
Yes, whatever is to be, we are closing the arguments by 11th or 12th. So you please talk with your advocate on record and be here, we will hear. We
Please,
have
my lords. My lords, we were here today, but I understand my learned colleague was addressing. I will not repeat anything, I assure you, but because we are for the private individuals.
hearing it continuously for a substantial period of time. We want
I understand. My lords, I completely empathize with what you are saying, completely.
কোথায় নোট করলাম হয়তো কে আচ্ছা মিস্টার দাশগুপ্ত learned hard Mr. Dasgupta learned advocate appearing for the
stayed in 2022.
So very good. He has adopted the submissions of Mr. Badi. That is what is committed. We are recording that. Lekhu. If it is not finished on 11th, we'll keep it on 12th and we are reserving judgment on that date. Please end your submissions.
My lord, only one thing, October 29, order, the order of October 29, last day, my lord. Your lordship recorded that Mr. Bhattacharya concluded his argument in respect of can 2 and can 3. If your lordship remembers, my lord, Mr. Bhattacharya also appeared for can 44 and 76, but that was not recorded. This is, my lord, I want that he appeared for can 44 and 76 also, because ultimately your lordship hold that I will record everything. It was not recorded. Can 44 and can 76 also Mr.
Or the next day we will include that.
Because other can was my can was with my data.
Next day, introduction 31 to 72, my learned junior, Mr. Kabir was there. Your lordships, I gathered the lordship wanted to know the read petition pending the numbers.
Yes.
My lord, we have.
Please give the list.
Yeah. And my lord, along with the
We
Kabir,
have
my lord,
adopted the submission of Mr. Shamimul Bari. আচ্ছা ওইটা বাড়িদার নামটা লিখে দিও ওইটা
qualified
Mr. Ekramul Bari, COVID assisted by Mr. Kabir, appeared on behalf of such and such.
Lord, I will remind your lordship on the next one. Deeply obliged.
Well, I have submitted my list.
No, please don't run away.
No, no, my
No,
lord.
no.
Roll number to the
Mr. Mojumdar,
there up. What has said
we
is
have
supported.
Mr. Dotto. We will give you half an hour more and we will. You will not hear the things which are against you. এই প্রথমটা বলে দাও তো যেটা রিজেক্ট
All right.